with that said, I am now going to turn it over to Adriano Lorenzo from Affinity Management Services. Again, thank you so much for having us today. We can't wait to get started.
Thank you so much for that whole introduction, Jeff, and thank you, Emily, for teaching this course. So well as Jeff so kindly introduced me, I'm Eliana Lorenzo. I'm the marketing coordinator here at Affinity Management Services. And I want to take a moment to tell you a little bit about Affinity. So at Affinity, we believe that strong communities start with informed leadership. That's why we place such a high priority on board member education. We don't just manage properties, we empower the people behind them. Through hands-on training, regular updates on legal and financial changes, and open lines of communication, we ensure our board members have the tools and confidence they need to lead effectively. But we don't do it alone. We partner with companies and service providers who share our commitment to excellence and community well-being. So thank you, KBR, for this opportunity to co-host. Together, we bring added value, innovation, and expert guidance to help associations thrive as well-managed, well-informed, and well-lived communities. So because Affinity, it's never just about managing buildings, it's about supporting the people who call them home. So in Affinity, if you like to explore more educational resources, we invite you to explore our expert corner on our website, managedbyaffinity.com. There you'll find weekly blogs by our CEO, Rafael Aquino, and we focus on the real needs of board members. We also host monthly webinars, which I kindly invite you to participate in. We share helpful videos on our YouTube channel. We have weekly videos coming out, and soon we're gonna have a very, very special kind of content that I know that you're gonna love, and we'll tell you more.
According for this class, of course. What else could it be?
Well, there's a little bit more stuff. You'll see. You'll see. We're preparing something. But stay connected on Facebook, Instagram, LinkedIn, so you can see what it is going to be about. And if you're looking for a personalized guidance, as we just kindly told you before, we're going to drop the links so you can connect to our sales team, who will be very, very happy to connect with you and explore the possibilities for your community. And just as a quick note, after you book that call, you will get the opportunity to get our recently launched playbook, where we also give our best tips for a well-managed community. So thank you so much for this opportunity, and I hope that you get all this amazing knowledge that Emily has to give today. I know this is going to be amazing for everybody. So back to you.
Thank you very much. And again, thanks for having us.
Thank you.
And we're about to get introduced to our instructor for today. And just keep in mind that anything you hear from Emily today, any questions I may answer on the Q&A, which will not be legal in nature to begin with anyway, I'll answer technical questions. Nothing today should be considered as legal advice. Okay. Please don't go back later on and saying, hey, I heard on this class today, Emily said this, that, and the other thing. That is not legal advice. This is for educational and certification purposes only. So with that said, live from our studios at the Pompano Beach office, our main office of Kaye Bender Rembaum, I'd like to now introduce Emily Gannon. Emily, please take it away. You are muted, my friend.
Oh, sorry about that. Hi, guys. All right. I'm Emily. Thank you for that introduction, Jeff. That was very nice. I liked how your voice made sort of a drum roll naturally. I like that. Now, I already saw a couple things. I think some people maybe logged on late. I know Jeff already covered this, but today's class is the HOA class, the Homeowners Board Certification Course. So if you're in a co-op or a condo, it does not apply to you. You're welcome to hang out, but it's not going to get you the credits you need. I know a couple people already commented, so I'm just clarifying that one more time.
No, and thanks for doing it. And I will, if I may piggyback on that, this is not this, nor is this a continuing education class for board members. That is probably coming midsummer. Okay, this is the certification aspect, not the continuing education aspect. This does not count towards that 4 or 8 credits that HOA that you're going to learn about today that HOA board members are going to need. This is not that. Emily, back to you.
All right, so let's jump in and let me introduce myself better here. Let's start with something for you guys to look at so you're not just staring at our screens. All right, so like I said, Homeowners Board Certification class. We've allotted 3 hours. I know there's the condo course is mandated to be 4 hours. So we hear a lot of rumors that the HOA class has to be 4 hours, but it doesn't. And honestly, we're going to try and do it under the 3 hours for you guys. I'm originally from New York. I can talk kind of quickly, so hopefully you can follow along. And as Jeff said, you are going to get all of these slides. You will have everything at your, fingertips. So you will have all of this information. I'm not going to read every single slide to you. That would be really boring. So I am going to sort of skip through some of the information, but you will have it and you can take it home. You can read through it. You can highlight it. I have mine printed out and highlighted and all that stuff. And you can do that, in your spare time. But we're trying to get you guys your certification and get you the most critical information that you need to be a new board member or serve on your board. So quick introduction for Kaye Bender Rembaum. And again, as sort of in line with what Adriana said about affinity, our law firm only services essentially associations. Occasionally we have individual clients or developer clients, but for the most part, 99% of our work is for the associations. We really want our board members to be educated. Just like Affinity said, that's really what's going to help you guys function and operate the best. So we do a lot of these classes. They are free. We want everyone to know what they should be doing when they're on a board. You can check out our website. We offer a lot of classes. And again, we've been in business for a long time. This week, I actually just realized is my 13-year anniversary with the firm. So I guess that means my time here would be getting a bat mitzvah or something. I don't know. Magic 13. So our main office is in Pompano Beach. That's where I'm located. We've started in Broward County. So we have a lot of Broward County clients and obviously Palm Beach County, Miami-Dade. We do have a Palm Beach Gardens office. So now we're sort of moving up the East Coast. We have an Orlando office. We have a Tampa office. And now we're moving across Florida as well and sort of moving all over Florida. So wherever you are, we can probably help you out if you are in the state of Florida. All right, so let's jump in. As Jeff said, well, there's my bio. You guys can read through that later. All right, so why are we here? Let's start there. Within 90 days after being elected or appointed to the board, you now must, and this changed last year. It used to be that you could sort of check off a certificate and say, that you'd read your documents and that was enough. Now you have to take a class. That is part of the deal. It's in the statute. You have to do it within 90 days of being appointed or elected. Now you have to take a course that's approved by the DBPR. And this course, that's what we're doing here today. This certificate that you'll get today is going to be good for up to 4 years. And essentially you're going to have to take a class every 4 years if you stay on your board. And we have to include training related to financial literacy and transparency, record keeping, levying of fines, and the notice and meeting requirements. And those are important topics, obviously. And a lot of that, you will have the assistance probably of your management team. A lot of that is sort of typically under their purview of what they're doing for you. But you really should be aware when you're on a board of what your requirements are, what the statute provides, and what you need to know and make sure. And really, then it helps you keep an eye and kind of help your management team too, but keep an eye on what's going on and what you should be doing. Especially if you're self-managed, obviously that's even more important, but these are the big topics. And I'll give you some context here. In recent years, you may have noticed in the news, there've been a lot of stories because it's a interesting, I guess, topic nowadays. There've been some stories of associations, condos, and HOAs where some board members have done things maybe they weren't supposed to do. There've actually been some arrests, and it had to do with stealing money, embezzlement, sort of using the membership funds for things that shouldn't have been used for, and then covering up those bad acts. So there was a lot of issues with getting access to records, and meetings weren't being held and elections weren't being held because obviously the board wanted to stay in power. So all of these things have kind of been going on, and that gives you the context of where a lot of these changes to the statute have come in, why we want boards to really know what's going on so that we prevent any of those things from happening again. that's the context, and keep that in mind as we go through all of this, because it will become obvious to you guys. Now, if you don't get your certification timely, technically you're suspended from the board. You can easily fill that, you can fill that vacancy during that time, but you can easily fix that basically by taking your class. Continuing education, this is also what Jeff mentioned. Now, this was a new requirement, and this is happening for condominiums too, but for HOAs, you guys, if you are in an association that is 2,500 parcels or fewer, then you have to do 4 hours of continuing education annually. So it's not just your board certification class and you're good to go. You have to continue to take these additional seminars and additional educational courses, because again, they want to make sure our board members are educated, our board members know what's going on, and really can understand the law here. Now, again, as Jeff said, little complication here. We put this in the statute, the legislature put this in the statute and said, board members are going to have to do this now, but we don't have any guidance from the DBPR in terms of how these courses are going to be credited, which courses will be given credit. Our firm teaches many, many seminars on different classes and different topics, and covenant enforcement, elections, fair housing issues. And we don't know if any of those will count, or if there are certain things and certain topics that they will only count for these continuing education credits. We don't know yet. And we're still all just kind of waiting and waiting and waiting. And you're supposed to get that done, but we don't have answers for you, and we're not sure how to get it done. So don't shoot the messenger here. I didn't do that. And I'm with you in terms of we're in limbo trying to see how this is all going to work. Hopefully, again, as Jeff said, we're assuming we'll get answers in the summer. We'll keep you posted. All right, so let's jump in. So as we said before, if you're in an HOA, you're governed by Chapter 720 of Florida statutes, okay? 718 is the Condominium Act. 719 deals with co-ops. 721 is mobile homes. But we are talking about Chapter 720 of Florida statutes. That is what governs an HOA. Hopefully, you guys are in the right place. Okay. Important to note, again, there are some differences. 720 and 718 used to be a lot more alike, and now they've sort of diverged a little bit more, but 718 is different. Condominiums only exist because of statute. We all say they're a creature of statute. HOAs, that's not the case. So many differences there. So make sure when you have questions about your association, if you're governed by 720, don't look at the Condominium Act. That is not going to help you. We get questions too about which version of 720 applies. And this is important. And this, again, we could get into a whole legal argument over these questions. But what you need to know and what's important for you is when your community was built. So let's say you were developed in, we'll just say the year 2000. Your developer, started developing, recorded your declaration in the year 2000. Whenever the parcels were sold and all of that, that's fine. We don't have to worry about turnover for the purposes of this conversation. But let's say your declaration is recorded in the year 2000. So then the question becomes, is your declaration locked into and sort of stuck in time with Chapter 720 as it was written in the year 2000? Or does it change with the years? And as the statute changes, does your version of 720 as it is in 2025, is that what applies to your community? This is always an important question because, again, we have been making more changes to the statute. And inevitably, when you make changes to the statute, clients will ask us, okay, so does that change apply to me? Does that mean I have to do XYZ, or we can't enforce XYZ, or whatever it is? And unfortunately, I can't give you a cut and dry answer of yes or no. It seems more, it depends. So there are many considerations. And again, this is an important conversation that you guys will need to possibly have with your counsel if you're talking about enforcing covenants and things like that. And we'll get into that later on down the road. But the main gist is, if the substantive law that was in effect at the time of a contract, and your declaration is a contract, that is sort of what you get to hold your, hang your hat on. So they're constitutional rights. It's in the Florida Constitution, as well as the Constitution, but basically it says you can't impose on a contractual right. So statute can't impose on a contractual right, which means if the statute does something that negatively impacts a contractual right, it's not going to apply. It shouldn't be enforceable. Now, again, that gets into a whole bunch of legal arguments, but the main thing you need to take away is, does your declaration have Kaufman language? The Kaufman language is your declaration subject to Chapter 720 as amended from time to time? Those are the magic words, as amended from time to time. That's the Kaufman language. If you have Kaufman language in your declaration, that means your declaration changes with the statute. That means, you know, it was 720 in the year 2000, and it's subject to Chapter 720 in 2025. If it does not have that language, then there's an argument that your declaration is stuck in the year 2000 with certain exceptions. And again, there's a whole argument here of what changes to the statute are procedural versus which changes to the statute are substantive. Again, if there's substantive, there's that whole contractual argument that those changes wouldn't apply to you. Now, to keep it simple, the easiest example, and again, we're not in condo world, but the easiest example is when they changed the statute to make condominium elections a certain procedure, and they said, here, you need these notices, you need to do all of that. Every condominium now follows that procedure for their election, and they follow the statute, even if their declaration says something different, because it was a procedural change. If it's a substantive change to the statute, then that's when we get into the Kaufman discussion and we try to figure out if it applies to you or not. That's where that contractual right and due process issues come up. Now, it's a substantive, figuring out what's procedural versus what's substantive can actually be more confusing than it needs to be, in my opinion. But that's where it can be a complicated argument or complicated issue, and you should really discuss with your counsel. Chapter 617 of Florida statutes, that is the not-for-profit statute. That's something that comes into play sometimes. It's sort of the fallback. It's kind of a little bit of a safety net. Sometimes it fills in the holes of something that's not covered by Chapter 720. But if there's a conflict between them, 720 is going to control, 617 is just sort of the backup. That's how you should think of it. If there is if there's a conflict between your governing documents, this is also something to remember. Essentially, and then we put this little ad in here, and we show you that the expression is, you know, a little dab will do you. Apparently, that's from a commercial from a long time ago, and I don't actually even know the reference. One of the partners makes fun of me when I say that, but that's the acronym you should remember. Declaration, articles, bylaws. Your declaration is your primary, you know, document here. That's the hierarchy. The declaration's on top, then your articles, then your bylaws, if there's any conflict. Articles and bylaws typically don't have the same restrictions in them. Your declaration really has your covenants and restrictions. Articles and bylaws typically have, you know, notice requirements, how many board members you're going to have, things like that tend to be in there. So there shouldn't really be a conflict, but occasionally it happens. So let's dive into some of these topics. Membership meetings. And again, we're talking membership meetings, not board meetings just yet. For HOAs, typically, you probably only have one membership meeting a year, and it's probably your annual meeting. Now, you have to follow what's in your bylaws in terms of when it's supposed to be held. Sometimes it'll just say, you know, in the month of February, or sometimes it won't say anything when the board decides, or sometimes it'll say on the, you know, second Tuesday of February at 7 p.m. at this, you know, at this location. Look at your bylaws. You really should be following that. Typically, that's when your election is also going to occur. So you may tell me we don't even have meetings, but there may be some confusion in terms of whether or not you have quorum at your meetings. And we'll get into that in a minute. Special membership meetings, typically that's just another meeting where your members would be voting. That isn't the annual meeting. Again, they're rare in the world of HOAs, but you might have a meeting where you're voting on an amendment or voting on, you know, something else, creating a reserve account. There could be something where the members need to vote and it's not actually at the annual meeting. It happens on occasion. And also the statute says that 10% of your total voting interest can petition for a meeting and have a meeting scheduled. You should have, unless your governing documents say so, the annual meeting notice doesn't have to have an agenda, but we always suggest you do it anyway. I don't know why it says that, but special membership meetings must have the agenda on there or the purpose for which they're called. That's important too. Notice requirements, and again, typically your management team is going to be handling this for you, but again, you guys are supposed to know this as well. Your notices should have the date, time, and location of the meeting. If the bylaws don't say anything, then it's you must mail, deliver, electronically transmit the notice not less than 14 days before the meeting. So that's your sort of our magic number is 14 days. The fact that you complied with that, you have to have an affidavit that demonstrates that or that reflects that. And that affidavit should be kept in your official records. And your notices are all going to be sent to whatever address is in the official records of the association that the owner provided you as their mailing address. So keep that in mind. Or it can be sent electronically if that owner has consented in writing to get electronic notices. Electronic notice requirements. This is again becoming more and more popular because people are willing to sign up and let notices come via email. That makes life a little bit easier, obviously, for your management team, cuts down on some mailing costs, which is always nice. But ultimately, your owners have to consent to that, and they have to agree to get their notices via email. Otherwise, you still have to send them hard copies. We do have some communities where they say, well, we send everything out via email. But if your owners haven't actually consented to that, and you should have a written consent form basically from them that says, yes, I would like to get my notices via email, then you could have an issue with challenge with one of your notices. What's up, Jeff?
I just want to mention too, just to strengthen your point, because this comes up inevitably every single time we do this. Even if you consent to email, it is the owner's responsibility to make sure that you can find the email. For example, if it ends up in spam, it's not going to hold the HOA or a condominium liable. I just wanted to make sure that we mention that.
Thank you. He's our tech guy, so he thinks about those parts of it. And yes, that is true. So so yes, if your owners have agreed and then they ultimately tell you I don't get all the emails, remind them to check their spam and check their folders and their filters and all of that, because if you are sending it to the email address that they gave you,
exactly,
you guys as the association are doing your duty and you're done. You're off the hook, but really they need to make sure they can get it.
And the same thing with this class, within a few days after this session, now that we have all of our attendees here, I just want to mention the email address that you used when you registered for this class. That's where we're going to send you your certificates of attendance for today. So keep tabs on that address and your spam folders over the next several days, because that's the address where it's going to go. Now that everybody's here, I just wanted to mention that.
Oh, should I mention something? We always get asked for these certificates too, but please note that the only ones that are allowed to issue these certificates are the lawyers. Like, for example, Affinity here, even though we're co-hosting today, we are not able to provide this official document to you. Thank you.
Thank you. Emily, we're going to keep interrupting you. Sorry about that.
No, that's fine. And then the only other sort of caveat here with electronic notices to keep in mind is you can't use that if we're talking about a possible recall. So little detail to be aware of if you're planning a recall. Now, websites, we're going to talk about websites a little bit. Hopefully you guys, this isn't news to you, because the change was by January 1st of 2025, an association that has 100 or more parcels is supposed to have a website. Hopefully, again, we're April now of 2025. So if that applies to you, I hope you have a website. You have to post the notice in the agenda of those membership meetings at least 14 days before on your website as well. We'll get into more details about the website later, and the other part of this is they really want to make sure the notices are easy to see, easy to find. So either, on the homepage, that should be sort of the first thing, very open and obvious. Or if you have, tabs, make sure that it's very clearly labeled notices and it is very open and obvious and conspicuous and easy to find from the homepage for your website. And when we say website, you could also have an app, any online platform, basically that where you can post these things. And again, we'll get into that a little bit more in a minute. And then if there's anything that's going to be voted on or considered at the meeting, 7 days. So there's a different time frame here, but 7 days before that meeting, the document is supposed to be up on the website. So if there's an amendment potentially, or again, something that the members would be voting on, that needs to be on the website as well. Now, members' right to participate. Keep in mind your owners, and hopefully you all know this, your owners have the right to attend all the membership meetings and to speak at the meetings. Now, really, that does not mean it's an open forum and they can talk about anything under the sun. It's all of the items open for discussion or all of the items on the agenda. So we always kind of caution our managers, our board members, when you're putting together the agenda, try not to have sort of that open-ended, good and welfare section or whatever it is, because then it sounds like you're sort of opening up Pandora's box and owners could talk about anything under the sun. And do you want to be there for 1,000 hours? But that's up to you. Maybe that's how your community is and you'd rather do that. Totally within your discretion. But maybe you want to keep that agenda a little more narrowly tailored so we stay on task and we get moving. Each owner has the right to speak for at least 3 minutes on each item, each topic. So again, depending on how big your community is and your participation, you could be there for a while. You can adopt some reasonable rules about the frequency, duration, and manner of those owner statements. So you can adopt rules in terms of how you're going to go through it, how owners maybe need to sign in, or whatever it is, the 3 minutes, it's going to happen in this order, whatever. You could adopt some rules. We can help you with that if you need some help. Owners can also tape record or videotape membership meetings. You can also adopt rules about that. So we have owners that will come in and just, they put their phone on, they're recording, fine. They want to have a script to listen to later, fine by me. You can adopt rules that they have to notify you perhaps in advance, things like that. You maybe want to have those in place, obviously, going forward. You wouldn't want owners to come in with, a giant boom mic and be, hanging out in the board members' faces and driving everybody crazy and distracting everyone from the meeting. So again, you can have those rules in place. Quorums and decisions, unless a lower number, and I don't know why, but for some reason this throws people off, unless a lower number is provided in your bylaws, your quorum requirement is 30% of the total voting interests when we're talking about a membership meeting. So if your bylaws say something lower, if your bylaws say 20%, 10%, that's fine. If your bylaws say something higher, majority, 51%, we're at 30. So keep in mind, lower is fine, but otherwise you're at 30%. And that's really for your annual meeting too. And if you don't get quorum, you can't proceed, you can't conduct the meeting, you can't conduct any business. In terms of decisions, unless there's something different in your governing documents, and sometimes there is, sometimes there's a requirement for 75% of your owners to approve an amendment, or 2/3 of your owners to approve XYZ. But typically, unless there's something in your governing documents, a membership decision is just made by a majority of the voting interest present. Proxies, this is an important difference in the world of condos and HOAs. You guys have a little bit more flexibility with your proxies. You can vote by proxy, or you can vote in person. You can come to the meeting and fill out a ballot, or you can hand a proxy to your neighbor and say, hey, can you turn this in for me? I'm not going to make it, but I wanted to vote in favor of the amendments and I've already, checked the boxes. And we talk about different kinds of proxies, but in general, for a proxy to be valid, it has to be dated, it has to have the date, time, and place of the meeting for which it was given, and it has to be signed by the proper owner, authorized voter, whatever it is. It is only effective for that specific meeting. And then if that meeting is continued or adjourned, it'll be good for at least 90 days. So if you're trying to get amendments passed, you can have somebody turn in a proxy, and maybe you don't get enough that night. You can make a motion to reconvene the meeting maybe 30 days later. The proxy that was turned in for that original meeting is still going to be good because you have it for that original date and then a 90-day window after. So anytime you're doing amendments or trying to get a vote to pass, that happens fairly often because it's hard to get the vote, get enough participation on the first go around. Proxies are also revocable at any time by the person who executes it. That happens often. Someone, turns in a proxy and then magically shows up at the meeting and says, oh, give me back my proxy. I'm here. I can vote in person, or I want to change my vote. And that's fine. Not the same as a ballot, but fine in the world of proxies. All right. Now, I said there are different kinds of proxies. There's a general proxy. basically giving my vote to whoever it is, and they can vote on a specific matter, or they could vote in any manner they want. Or a limited proxy actually directs your vote on a specific item. So it's really that, for a limited proxy, if you had maybe those potential amendments that were outstanding, the limited proxy would have a space for you to already vote for or against, or yes or no, or however it's written. But I would be filling out my proxy and I would indicate how I'm voting. The general proxy, usually it's for quorum, but also, again, maybe there's an election, maybe you want to let your neighbor vote for you and you don't know who the candidates are yet, so you give them their general proxy, and that neighbor is going to show up and get 2 ballots that night now. All right, electronic voting, that's an important sort of new, well, not so new anymore, but now it's become a lot more popular in the last couple of years. COVID really helped it out. Electronic voting used to be, I think associations were worried it was too cost prohibitive. Now my understanding is it's very reasonable. There are a number of platforms, there are a number of communities that can help you out with electronic voting. Obviously, for the convenience factor, it's great. You can have your owners, I am in South Florida, so we do have a lot of owners that are snowbirds. They're not here all year round, or a lot of international owners who go back to Canada or go to South America, and they still want to be able to participate and vote for maybe an amendment or even in an election. And obviously, if they can do it via the internet, all the better. To set up electronic voting, there is a very specific process that has to be followed. If you want to consider electronic voting, talk to your attorneys and make sure you do it in the right way. Again, it doesn't just mean somebody gets to email their vote in and say, oh, I decided I wanted to vote yes in favor of amendment number 1. That's not going to count. Electronic voting has to be done in a specific way, following specific rules. So step 1 is a board vote to just implement it, and that's a 14-day notice. That's one of the exceptions to the typical, board notice requirement. 14 days, the board has to adopt a resolution where they spell out, that they're going to follow all of these requirements, that the platform is going to have certain deadlines, procedures, all of that. Again, talk to your attorneys, make sure you're doing this right if that's something that interests you. Also interesting to keep in mind, when you participate in an electronic voting and you vote online, it counts towards quorum. So that is also very helpful when we're trying to get quorum established, especially in the world of an HOA, when you want your owners to participate. Excuse me. The online voting system has to allow each owner to authenticate their identity. It has to, again, let them confirm that their system is going to work. It has to transmit a receipt to them that their vote went through or whatever it is. And then another important part of this is it has to basically be able to separate out any election voting, any ballots, so that you can't decipher that Mr. Jones, who logged in under his, who cast an electronic vote from, Mr. Jones at yahoo.com, that you can't know that Mr. Jones voted for Mary and Bob and John and Joe for the election. But you'll just know that Mr. Jones voted, and you've confirmed Mr. Jones is from, 123 Green Street. He is the owner and he has voted. But you won't know who he voted for. So that's an important piece of that whole puzzle. That's why these platforms really need to be set up properly. All right, so we'll get into elections. We've already sort of referenced them a little bit here when we're talking about meetings. A vacancy on the board that's caused by the expiration of a director's term must be filled by an election. So a vacancy just because somebody resigned or stepped down or moved or whatever it is, that's different. You look at your governing documents. Typically, the rest of the board can just appoint somebody, and that'll be fine. But if we're talking about somebody's term ending, then we need an election to fill that spot now. This is supposed to be done with your annual meeting. As we said, you have to follow the procedures that are in your governing documents. You need to establish a quorum in order to proceed. This is what we mentioned a little bit before. So in order to have any meeting and conduct any business, you need to establish quorum at your meeting. So that is step 1, even in having an election. If the only item on your agenda, essentially, at the annual meeting is to have an election, Step one is still, we have to establish quorum. You have to get enough people there, which again is probably going to be that 30% that we talked about. Once you get that 30%, now we can proceed. Now we can have the election. If we don't get that, then we can't proceed. We can't have an election and your board just rolls over. That's why, again, like I said, typically we hear a lot of communities, and this is more common in HOAs, but a lot of communities that will say, we haven't had an election in 10 years. We've had the same board forever and ever. I don't even know how to get on my board, even if I wanted to get on my board. Now, if you gather enough proxies, hopefully that would get you to quorum and you'd be able to have an election. Or perhaps you want to talk to your board about adopting a different procedure and putting in, an amendment to your bylaws that makes your election more like a condominium, where you could do it with advance notice, with, notices of intent from candidates, and you could vote that way. These are all options, because again, I hear it a lot, that condo or HOA world, I hear we never have an election. So those are my tips. Gather some proxies, try and get quorum, try and, that's your best bet, or amend your documents to make your election procedure a little different. To be eligible to serve on your board, it's all members are going to be eligible under the statute unless they're otherwise disqualified. And the statute outlines exactly who that applies to. Now, again, given the context that we discussed at the very beginning of today's lovely seminar, you'll see why some of these criteria are in here and why some of them have been changed in recent years. One that has not changed and has been in place for a while, if someone is delinquent in the payment of a monetary obligation on the day that he or she could last nominate themselves, they cannot be listed on the ballot. They are not eligible. They cannot be a candidate. Now, for most HOAs, the election is happening the night of the annual meeting. So we show up, we establish quorum, we've checked in all the proxies, we've checked in all of our owners. Magically, we hit our 30% number, we're good to go. We can actually have a meeting, and perhaps we announce, okay, now we're taking nominations from the floor. And, a couple people will raise their hands. Okay, yep, I'd like to be on the board again. Or, oh, I'll run this year, whatever it is. People nominate themselves. So often for HOAs, it's that day, that time, the evening of your annual meeting, that you have to make sure you're current. If you are delinquent in the payment of any monetary obligation, you're not supposed to be a candidate. You're not supposed to be on the ballot. So again, make sure you are current if you want to run for the board. And that's in any monetary obligation. So, it could be anything. It could be a fine. It could be a late fee. It doesn't necessarily have to be your most recent assessment payment. Another criteria, if you've been convicted of a felony in Florida or another offense that would be considered a felony in our state, you're not eligible to serve on the board unless your civil rights have been restored for at least 5 years. Now, I get questions. How would we ever know that? Are we supposed to run background checks on all of our candidates? I don't know what to tell you with that. No, don't run background checks on all of your candidates. But you're right. Odds are you probably wouldn't know that. But typically, management teams will have some sort of disclaimer on the, on the documentation, or just let the owners know, hey, if you've been convicted of a felony, you're not eligible. And usually that is enough to make sure that, no one who's not eligible puts their name in the ring. This is the new one because of, again, that context we talked about earlier. A person who has pending criminal charges for forgery of a ballot envelope or a voting certificate used in an election, or felony theft or embezzlement offense involving the association's funds or association property, or tampering with physical evidence, or obstruction of justice, cannot be elected to any board. So if you have pending criminal charges for those things. Now, again, this is all because of the context I talked about earlier, because we did have these bad actors in the world of condos and HOAs. We want to make sure, again, we minimize that risk and try and keep that from happening again. So if anyone has pending criminal charges for those items that are all related to, association elections and association operations, they cannot be elected to a board. And notice that was pending charges, not convictions, charges. So it's important. Nominations, like I said, you can nominate yourself as a candidate at the meeting. So again, nominations from the floor, hey, we're going to open up nominations, and you let people, okay, I'll run. Okay, I'll run. I'd like to be on the board, blah, blah, blah. You can nominate each other too, but you can nominate yourself. So it doesn't have to be, hey, will you nominate me? I feel, nope, you can nominate yourself. I'd like to run. That's all you need. If you have a process in your governing documents that lets you do nominations in advance, then we don't have to allow the nominations from the floor. And that's, again, also helpful because sometimes you can do it where, you can get the nominations in advance and then people can campaign and then everyone knows who they're already voting for, or they have an opportunity to do a little research as opposed to just showing up and going, oh, wait, who are our candidates? So that is a nice procedure to have in place. If you have one of those sort of old provisions about a nominating committee, but it doesn't allow someone to throw their hat into the ring, it instead says something like the nominating committee will choose its own candidates and will, pick 3 candidates that it likes. If it doesn't allow an individual owner to be able to nominate themselves, if that procedure doesn't allow for that, then you do have to allow the nominations from the floor. So again, if the nominating committee takes, anyone who's interested, that's different than a nominating committee is going to pick 3 of their favorite candidates, and those are the names. If that's the case, something like that, then you would have to allow the nominations from the floor. There has to be a way for an interested candidate to get their name out there and to nominate themselves. That's important. Election day, if we don't have more candidates than we have seats, then it's an election by acclamation. We just seat the new board, no problem. You do have the right to vote, like I said, in proxy or in person or by proxy, which is again different than the world of condominiums. Unless the bylaws provide otherwise, directors serve 1-year terms. You could have staggered terms. You could have 2-year, 3-year terms. Maybe you only elect half the board each year and you're doing staggered terms. That would be fine, but that would have to be something in your bylaws. Election challenges. This is also interesting because you guys are in HOA land, but yet your election challenges could go through the division of condominiums, timeshares, and mobile homes. That's one of the items they have jurisdiction over. Any challenge to the election process has to be commenced within 60 days after the results are announced. And again, like I said, that could go through the division, which is interesting. Officers are elected immediately following the election, typically. There's an organizational meeting, a board meeting right after the election happens. This is also random piece of trivia. It's the only time the directors get to vote by secret ballot is at that meeting if they want to decide who the officers are. So no other time can directors vote by secret ballot. Everyone gets to know what the director's vote is on everything else, but that's the only time. Now, the officers, your owners are voting to put people on the board. So they vote, and you pick the top 5 vote getters. That's your new board, maybe. Now, if we're in a community where we're a board of 5, those 5 people now, they get to decide who's going to be the president, who's going to be vice president, who's going to be secretary, who's going to be treasurer. They decide. Those 5. Those are the only voices really that count at that point in time. And I've been at meetings where owners will say, well, I voted for Joe, but I want Joe to be the president. Well, thank you, owner, for voting for Joe. Joe made it to the board, but now the board members get to decide who the officers are. You don't get to decide, I want Joe to be the president. So keep that in mind. That's also a distinction a lot of owners get confused about. And they'll say, I also hear things like, well, Joe got the most votes, so he should be president, right? It's entirely up to you guys. If 3 out of the 5 of you decide Joe should be president, Joe's going to be president. But if, it doesn't have to be because he got the most votes. If 3 out of the 5 of you decide, I really don't want Joe to be the president, he actually gets a little hot-headed, maybe that's not the best role for him, then you can make Mary the president, whatever it is. As long as, again, the directors are the ones who get to vote and get to decide who the officers are going to be. And they can change that at any point in time, keep in mind. Just because, you're appointed president at the annual meeting doesn't mean you're going to be president all year. Maybe that doesn't work for you. Maybe that doesn't work for the rest of the board. You could change officer positions. You could reorganize at any point in time. The board can do that. It's a 48-hour notice. They could do it at any board meeting. All right, fraudulent election voting activities. Again, this goes back to some of the context that I was talking about earlier. A person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. So it may sound silly to say that, you know, an HOA election is a big deal, but it can be. And obviously, if you are engaged in any of these activities, you're committing a crime, an actual crime. So be aware, and obviously I'm going to assume that everyone who's on here wouldn't do any of these things anyway, but be aware that even though you probably already knew they were wrong and you probably already knew they were illegal in some way, shape, or form, now we have also added it to Chapter 720 and just reiterated that these are illegal actions and you could be subject to criminal penalties. So willfully and falsely swearing or affirming an oath, basically in connection with a voting activity. So signing a false affidavit, something like that, that you should already know that that's illegal and improper, but now we've again solidified it in Chapter 720. Perpetuating or attempting to perpetuate fraud in connection with a vote cast or to be cast or attempted to be cast. Preventing a member from voting by fraudulently changing their ballot or their voting certificate. Menacing, threatening, or using bribery or corruption to influence or deter a member when voting. So again, that's not just, hey buddy, could you do me a favor and, you know, make sure you vote for my friend Joe because he's a great guy. That's a different level of, you know, menacing, threatening, using bribery to influence votes. Again, these are all things I would hope you already knew were illegal, but now we've really solidified they are also crimes under Chapter 720. Giving, promising anything of value. So again, sort of that bribery, that's another one. Using any force, violence, or intimidation or coercion to, again, influence someone's vote. These should all go without saying, but I have to say them anyway. All right. So this was, we're going to hit on a lot of the new laws, but now that we're already months in, because these were all effective July 1st of 2024. So first-degree misdemeanors, knowing, aiding, abetting, advising a person in the commission of fraudulent election voting activity, conspiring, combining, confederating with at least one person to commit fraudulent election activity, or having knowledge, giving aid to an offender with the intent to assist them in avoiding or escaping detection, arrest, trial, or punishment. So again, make sure you are not doing anything inappropriate. Even if it doesn't seem like a big deal because we're just talking about an HOA election, these are now crimes. It is no joke anymore. All right. Vacancies on the board. We talked about this a little bit. Essentially, look in your governing documents. If somebody resigns, somebody steps down. You could also hold another mini election if you wanted to, but look at your documents. Odds are the rest of the board can just appoint somebody. Now we'll get into the board of directors. So this is important. When you are on the board, and I hope, again, you guys already know this, when you're on the board, you have a fiduciary responsibility. You have a fiduciary duty. The same way, you know, not quite the same, but the same way that as a lawyer, I have to put my client's interests ahead of my own, for example, you guys, as board members, have to put the association's interests above your own. So, and now the obvious example is, well, we need a new roof on the clubhouse, so we're going to adopt a special assessment to pay for it. Well, obviously, you individually probably don't want a special assessment. You probably don't want to have to pay more money for anything. But you as a board member recognizes the association has to maintain the clubhouse. Clubhouse needs a new roof. We need to fund that. We're going to need to adopt a special assessment. That's a nice, clear-cut, easy example where you put the association's needs above your own. The big key here is that you must act reasonably, and we call it, it's the term here is the reasonable business judgment rule. There's some case law behind it that as long as you act in a way that another reasonable board member would under those circumstances and with the information available to you, you are going to be protected from personal liability. And that's important. We get a lot of board members who ask us because they're very worried about doing something wrong and exposing themselves to liability personally. Now, I can't promise you people aren't going to sue you anyway. But as long as you've acted reasonably, you are protected and you're not doing anything, again, inappropriate.
Emily, take a drink of water. I'm going to remind everybody that that the link for the evaluation, I've gotten this Q&A a few times here in the Q&A section. If you don't see the chat area, press the chat button one time simply so it appears. Okay. It will say chat is disabled for you, but we can still send stuff your way. So all you got to do is hit the chat button one time so it shows up. Later on, that's where we're going to place the link for the evaluation. And remember too, if you came in really late and you fill out an evaluation, it doesn't mean you're going to get a certificate. You must have been here from the grace period, which is about 10 to 15 minutes in when we were doing all our intros and talking. Okay. So we, between the evaluation and the attendance sheet, that's how we determine who's going to get their certificate sent to them to the email address you used when you registered. Back to you.
Thank you, Jeff. Sorry, guys, I have a sinus allergy situation happening. I'm a mess this week, but all right. So business judgment rule, important for you guys to be aware of this. Because again, we get board members who are very worried about their own personal liability and I don't know what to do. And the board is making these decisions. If you are acting reasonably, again, with the information available to you, and I don't like to use the example of Surfside because again, what happened in Surfside was terrible, but that's where you have to think about from, again, what we heard, board members were told by experts, by whoever else, that certain things needed to be done. Maintenance, whatever, repairs, whatever it was. That's where you need to be worried. If you are an owner and you have experts who are telling you that you need to do X, Y, Z, the association, again, the example I used about the clubhouse, the association has to fix this clubhouse. The roof could, if you have a report that says the roof could collapse and you're not doing anything, you're going to have a problem, obviously. But if you're acting reasonably, okay, great. We got to get bids. We got to get an engineer out here. We need to do what we need to do. Now, hypothetically, if you pick the wrong roofer and the roof, ends up, the job doesn't turn out so great, or, he steals your deposit and you never hear from him again and you got to find another roofer last minute. Those things happen. That does not mean you did anything wrong. If you pick sort of the wrong vendor, it does not mean you did anything wrong, as long as you did your due diligence and you listened to your experts and you did what you were supposed to be doing. So the reasonable business judgment rule is very important, and you guys should be aware and sort of take some comfort in that. As long as you're being reasonable, you're going to be protected individually. Now, also important, unless there's been some authority delegated by the rest of the board, no one board member should be making decisions for the entire board. Now, certain little things, the daily occurrences, communications, maybe with the manager, maybe that goes through the president. Maybe the treasurer has certain connections when we're talking about certain things with the bank accounts and, signing checks, that kind of thing. But we hear a lot of these stories of communities where the president is a dictator and nobody knows what's going on and he just makes decisions and nobody knows even what's happening. That should not be the case. Every decision should be made really by the board. Remember that, please. Board members can use email as a means of communication. You are not supposed to be voting via email. So if you have a decision to make, if you need to vote on something, that should still be happening at a duly noticed board meeting. All right, board meeting notices. So your board meeting notices have to have the agenda. They have to identify where the meeting is taking place, the date, time, all of that. If we're talking about an assessment, this is very important. That notice has to have an indication that the assessment is going to be considered and the nature of the assessment. So when we're talking about special assessments, again, maybe we have to assess for the clubhouse roof, there should be an indication on there. We're having a special board meeting to discuss a special assessment to repair or to replace the clubhouse roof in the approximate amount of $100,000, $200,000, whatever the amount is. So your purpose, the amount, all of that should be on the notice. Typically, your board meeting notices are only 48 hours. They have to be posted conspicuously in the community. Unless your bylaws say something different, the special assessment meeting or an amendment, if you're having a meeting to discuss an amendment to a rule that concerns parcel use, or you're discussing adopting electronic notices or electronic voting, it's a 14-day notice for that board meeting. Those are the only exceptions. Otherwise, it's 48 hours. Your website has to have that notice like we talked about, but it also needs to be posted in the community as well. So that doesn't get you out of having to post it. The notice, now, this is the other lovely complication. So now your notice really should have a hyperlink to the website or to the app, whatever you guys have, an app or a website, on which the meeting notice is posted to. All right, so new law, we talked about this a little bit already. January 1st of 2025, if you have 100 or more parcels, you have to have a website. Website or app or, again, online platform, whatever we're calling it, those are all being used interchangeably here. And notice of board meetings, the agenda, any other document, all of that needs to be posted on your website as you're going forward. Member participation, very similar to what we talked about with membership meetings. Owners have the ability to participate in the meetings. Now, there are 2 exceptions for when your board meetings need to be open. Typically, again, every board meeting should be duly noticed and open to your membership. Your membership gets to participate, they get to come out, all of that. Except 2 things. If it's a meeting held for the purpose of discussing personnel matters, or if it's a meeting between the board and legal counsel needs to be there, even if it's just on the phone or via Zoom or whatever it is, with respect to proposed or pending litigation. So those are your 2 exceptions, personnel matters or basically proposed or pending litigation with the attorney. Now, personnel matters does not mean, everything under the sun. Pending or proposed litigation also does not mean everything under the sun. Now, we still would tell you to be extra cautious. You can notice those meetings, but now they're not going to be open. So you notice it as a closed meeting, still giving 48 hours, a closed meeting with counsel to discuss pending litigation or to discuss personnel matters. You don't have to put anything more specific. You don't have to say, because we're talking about, Mr. Jones, our maintenance man. Personnel matters is fine, or pending or proposed litigation with the attorney. That's fine. But I would still suggest doing a notice, just indicating it's a closed board meeting. But that's it. Those are the only times you're doing closed board meetings. Everything else is open to your owners. We hear that a lot where boards will say, but it's a closed board meeting because we're talking about a sensitive topic. That doesn't cut it. It's not just because we decided it's a sensitive topic. It has to be one of those exceptions. Otherwise, it has to be open to your owners. Members have the right to attend, like I said, the right to speak. You can adopt rules for this as well. We suggest you do have rules in place, so you keep your meetings sort of moving along. An owner can videotape or record, same thing with your membership meetings. Board meetings are supposed to be held at a location accessible to physically handicapped persons if somebody has requested it. Keep that in mind if you have someone who is in a wheelchair, needs access, needs to make sure it's in a building with a ramp or whatever it is. All right, board members and compensation, question we get all the time. So board members, committee members, officers cannot directly receive any salary or compensation unless or except you can get reimbursed for out-of-pocket expenses. If you have to make some copies of a contract and the copier goes down in the clubhouse and you got to run to Kinko's and you spend, $30 at Kinko's making copies, okay, you can get reimbursed. If it's insurance proceeds, and this is the big one, if it's actually authorized in your governing documents, and occasionally that happens. Sometimes there's something in the bylaws that your officers actually can be compensated or paid a volunteer salary of whatever. I've seen that a few times, not often, but a few times. This is what we're worried about, kickbacks. So again, everything we talked about, the context that we started with when we were talking about those bad actors, so to speak, this is what we're worried about. You can't take kickbacks. Again, that should be obvious. That should be clear. I shouldn't have to say that, but I have to say it. So officers, directors, managers cannot solicit, offer to accept, or accept a kickback. And we hear it. We hear the rumors all the time. Hey, we're taking bids. We're going to maybe give out a contract for a huge deal because we're going to, whatever it is, repaint all of the townhomes. And, or we're going to re-landscape the clubhouse and the entranceway.
This is Del Boca Vista. This is Jerry Seinfeld's father showing up with the new Cadillac.
Right. And lo and behold, hey, our president just redid his yard and it looks pretty good. Now, again, who knows? Did he use that company and then decide, hey, that company could do good work for the whole community? Or is there some sort of quid pro quo going on? Hard to tell, but we want to make sure you guys all know, do not, if there's any question, do not take anything of any value from a vendor. If for you as the actual director, or for anyone in your family, if there's been no consideration, do not. It's illegal. You'll get kicked off a board. Now, so again, any director who violates this prohibition must immediately be removed from the board, and it creates a vacancy to be filled by the rest of the board. Now, an officer or manager or director can accept food to be consumed at a business meeting with a value of less than $25 per individual. So again, if a vendor puts on sometimes we do seminars with some of the individual vendors too, contractors, things like that. And you get cookies and coffee, that's fine. Services or goods received in connection with trade fairs or educational programs, same thing. You can get the swag from, their merch booth or whatever it is, that's fine. Now, grounds for immediate removal. Now, let's look into this. Director or officer charged by information or indictment with any of the following crimes must be removed from office. Now, what's important there, and in my original, my first years out of law school, I did some criminal work. So this is fascinating to me. If they're charged by information or indictment, so that does not mean convicted. It means charged. So that's interesting. So you don't need a conviction here. You just need to be charged with any of the following and you're off the board. Forgery of a ballot envelope or voting certificate used in an election, theft or embezzlement involving association funds or property, tampering with physical evidence, obstruction of justice, any criminal violation that's basically mentioned in 720. Now, like I said earlier, these are things that you should already know as board members are A, inappropriate, and B, illegal. On some level, you should know that forging documents, theft and embezzlement, tampering with evidence, you should already know those are illegal actions. But now, again, we've reiterated this in 1,000 different places. It's, even more illegal, and it'll get you taken off a board. Now, what's interesting here, though, so like I said, that's when you're charged, you can be removed from the board. If the charges are resolved without a finding of guilt or any sort of plea of guilty or no contest, that director or officer can be reinstated. So let's say, a director is charged, the state attorney's office has a pending case against them for whatever it is, fraud or embezzlement, and lo and behold, it's all a big misunderstanding. It gets cleared up, charges get dropped. Well, you can put that person back on the board now. That's fine. While the criminal charge is pending, that person cannot be appointed or elected to a position as an officer or director of any association and cannot have access to the official records of any association except pursuant to a court order. And that's important too, because we do have a lot of associations where they have an owner that has multiple, properties and they're on many boards or they're part of many associations. So if you have a criminal charge pending anywhere, you're not going to be on any board and you're not going to be able to get access to any records. I'm okay with that. My 2 cents here. An owner or director who becomes more than 90 days delinquent. So remember, when you are trying to run for the board, to be a candidate, you have to be current, cannot have any monetary obligation outstanding, or you cannot be a candidate and you cannot be on the ballot. When you're already on the board, we give you a little grace period. You get a little wiggle room. You have to become more than 90 days delinquent, and then you're kicked off the board. So you have a small window there to make sure you're current. Now, it's 90 days, more than 90 days delinquent, and the way the statute reads, it says you've deemed to have abandoned your seat. So it's by operation of law, more than 90 days delinquent, you are off the board. The rest of the board can then fill this vacancy the way they would any other vacancy. If you show up to the, management office with the check in hand and your funds clear and you're caught up and you're back, you're current and now everything's all good, it does not mean that you're automatically back on the board. Now keep that in mind because that comes up a lot. The board sometimes will say, the rest of the board members will say, well, we really didn't want Joe anyway. He was kind of a pain. And now do we have to put him back on the board? No, you don't. It's a vacancy and it was by operation of law. If he became more than 90 days delinquent, great that he's paid now, but you don't have to give him back his seat. You could appoint somebody else. Now, if you wanted to put him back on the board, if the rest of the board was okay with it, really liked Joe, great. Once he's current, put him back on the board, no problem. But that's an interesting one because that comes up every now and again. Conflict of interest disclosures. This is another topic that, again, is all sort of part of what we're trying to avoid. We want to make sure there's no, insider trading dealings and kickbacks and all of that. So conflicts of interest are important. We want to make sure everybody's on the same page and there are no conflicts. So directors and officers have to disclose any activity that could be reasonably construed to be a conflict of interest at least 14 days before the vote or entering into a contract that's part of that. So now they've outlined that a rebuttable presumption of a conflict exists if any of the following occurs without that prior disclosure. So if the officer or director enters into a contract or for goods or services with the association, or a relative of theirs basically enters into a contract with the association. So here's the way to think about it. If your vice president happens to also own the best landscaping company in all of Palm Beach County, part of you may say, well, wait a minute. We shouldn't hire that landscape company because then that would be uncomfortable. Bob's on the board. It would look strange, but maybe they are the best landscape company in Palm Beach County. And maybe Bob's going to say, hey, listen, it's my company. I'll give us the best deal around. No problem. We'll get the best service. My guys are on top of everything. Great. So again, while it at first glance may sound like maybe we shouldn't do that, when you look at it further, it could actually be a very good thing for the association. So it doesn't mean it's necessarily prohibited or forbidden. There is a process where you can actually enter into a contract with a vendor or contractor that's related to one of your directors and that they have some sort of financial interest in. Like I said, the example of, Palm Beach County's greatest landscape company that is also owned by your vice president. There is a way to do that. You can follow the steps here. It's basically an additional vote of the board. Well, it's a vote of the board, I should say, with an additional requirement of more votes. So it's not just a majority of the board approved going forward with ABC Landscaping. It's 2/3 of the board have to approve going forward with ABC Landscaping. And Bob doesn't get to vote on that matter, which makes sense because he's the interested party. He steps out of the room. He may tell you, here's my pitch. Here's why my company's great. And now you guys vote and I'll step aside. And again, as long as that contract is reasonable and fair, that's fine, which I would assume if you're approving it, it should be. Another little caveat to be aware of, at the next regular or special membership meeting, you are supposed to disclose that contract to the membership so they become aware of it. And in theory, and I haven't seen this happen in 20 years, a member could make a motion to cancel that contract by a majority vote of the membership present at that meeting. I don't know why that would happen, but it could, but just be aware. So there is that little caveat that your membership could sort of, overrule you guys and void you or void that decision. But rare that would ever come up. All right, we'll get into official records. A very frustrating topic, to be honest, at this point. Official records, and this is, hopefully now this is not a new topic for anybody watching, but as an association, you have to keep certain records. You have to have the official records of the association. There is a long list of everything that includes. The list is here. I'm not going to read every single item, but it's everything that you probably think of. Your governing documents, your, associate or your insurance policies, copies of contracts, all of that is part of the official records. You have to hold on to it. All of your financial records have to have all of that. Now, an exception, all of your ballots, sign-in sheets, proxies, all of that, you only have to hold on to those for 1 year after the date of the election or the date of whenever that vote was. So only 1 year do you need to hold on to the ballots, the proxies, all of that. And then the catch-all at the end of the statute here is all other written records of the association that are not specifically identified, which are related to the operation of the association. So all written records, okay? So you got to hold on to all this stuff for at least 7 years. That's the overarching rule here. Now, again, ballots, proxies, all of that, only 1 year. Bids, only 1 year. Keep that in mind. Now, again, this shouldn't be anything new, hopefully to you guys, but in July, there was a new law that went into effect that the association has to have written rules governing the policies for their official records. Now, my understanding, and I know I've talked to Affinity about this specifically, if you're managed by Affinity, hopefully you have already adopted those rules, because I know they already had them in place and they had samples for all of their clients. So hopefully your management team has taken care of that for you. Adriana, tell me if I'm wrong. Okay.
You're totally right.
Okay.
We make a good job on following the rules just as they are, because we have great partners as you two.
Thank you. All right. So now, just because you have to keep a whole bunch of official records, what does that mean and how does this work? There are a bunch of records that you have that are not going to be open for owners to inspect. So that includes records protected by attorney-client privilege or work product privilege. Any information, this is an important one, information that's obtained in connection with the approval of a lease or sale or other transfer of a parcel. So if you are in a community that reviews sales and leases, and many of them do, I would venture to say most, you probably run background checks, you have applications, you have all of these things, you have a lot of obviously personal information, you have bank accounts, potentially, you have, income statements, tax returns, whatever else you might have. It makes sense when you really think about it, that is information that should not be open for inspection and that your, owners shouldn't have access to. So when you think about it that way, it makes sense. So any information obtained in connection with the approval of a sale or a lease or other transfer. Now, information obtained in a gated community in connection with guests, visits to owners or residents. That also came up. That was a change some years ago. You had, sort of security logs or guest logs or whatever it was, records of who's coming through the gate at what times and who they're going to see. That's now something that is not open for inspection. And then essentially, and this is the one that seems the most obvious, any personal identifying information, social security numbers, driver's license numbers, credit card numbers, those things you may have, because you may have, if you're a 55 and over community, you may have copies of driver's licenses. If you, again, run background checks, you may have this information too. Now, that is a little different if we're talking about contact information. So addresses, telephone numbers, those things that were given for notice purposes, that were given to the association so that you can send them the notice of a meeting or whatever it is. Those things are open for inspection. Now, we'll get into personnel records. They're not going to be open to your owners. Medical records, and sometimes we get owners or boards that say, why would we have any medical records? You might, because you might have potentially someone who submitted a request to bring their assistance animal into the clubhouse or to have their assistance animal in a no pet community or something like that. And maybe they gave you medical records, a letter from a doctor or whatever it is. Those are not going to be open for inspection. Any passwords, security measures, none of that's open for inspection. Attorney-client privilege, that's obviously, something, if you have questions about that, talk to your attorney. So any emails that are, from my firm, for example, to the board, that wouldn't be open for inspection. Any letters, any things like that, that shouldn't be open for inspection. Membership directories. An association can actually print a directory. You can put the name, the address, and the telephone number of your owners in a, compiled in a directory if you'd like. We do tell you, though, you have to be able to, or your owners have to be able to exclude themselves if they would like. So give them the option first before you, publish that information. All right, providing rules and covenants. So again, this was sort of a recent new law, but it didn't give you much time to comply, and we're already past the deadline. So hopefully you've done it before October 1st of last year. So 6 months ago or whatever, wherever we are in the year now. The association is supposed to provide a physical or digital copy of the rules and covenants to every one of its members. Okay, so again, if you haven't done that, check with your management team. Maybe they sent out already. Yeah.
Can you clarify something when you say provide physical or digital copy? Because this is going to come up in the Q&A. It always does as well. Is when you say provide a digital copy, does that mean emailing it to somebody, or does it also mean, or does it only mean placing it on the website and saying, hey, sign up for our website, and that's where you can go get it. What does that?
I have seen that too, and I think that counts. So basically, if you sent out a notice to everybody, hey, the new rules or the rules and covenants are all on our website. Here's the link, and here, contact us if you need a password, whatever.
Okay.
That would suffice.
Cool. Yeah.
But you can't just put it on the website and not tell everybody.
Right. That will inevitably come up. So thanks for clearing that up.
Yeah. And then obviously when those rules are amended, you're also supposed to provide a copy of all of the rules to your owners. And then as they're amended, same thing, send the amended version out. Now you can comply, like we said, with posting a complete copy on the website, but now that has to be, the website has to be accessible to all of the unit owners or to all of your parcel owners. And you have to send a notice to each of the owners that it's there. Otherwise they don't know. So you could do that by email if they've consented to email notices, or we're back to, hard copy, send a mailer, it could even just be a little postcard. Hey, we have some new rules on our website, here's the link, check them out. Access to official records. This is why this topic is important. We want to make sure you guys are providing access to the official records. The whole focus here is make sure your owners know what's going on. They know what their money is being spent on. They know what the board is doing. They need to have access. There needs to be transparency, all of those good things. So if you get a request to access records, to make copies, whatever it is, you have to respond within 10 business days. And we would say make the appointment within, or offer an appointment within 10 business days. You can have a copy of those records available, or even better, if all of your records are electronically on your website or they're on the internet, then you don't have to have the person come into your office and sit down and go through everything. You can tell them, oh, you've requested to see whatever it is, the minutes from October and November's meetings. Great, they're on our website. And that fulfills your duty. You can just tell them, if the documents are on the website, you're done, you've complied. Or you can allow the records to be viewed on an electronic format or on a computer screen and then printed upon request. So instead of the old days of having, boxes and boxes and boxes in an office, you could have a computer with just, a USB drive or whatever it is with all of the records already saved on there, scanned, and have the owner come in and just basically scroll through and look through the USB drive. That's an option too. Now, if the request is submitted via certified mail and you don't respond timely and you don't provide the access within that time, there's a rebuttable presumption that the association willfully failed to comply, and there are penalties, $50 per calendar day up to 10 days, and then damages as well. So you could get attorney's fee, you could get hit with attorney's fees and this penalty if you don't comply. Another challenge or another change that came up due to challenges when people were trying to investigate all of these allegations from these bad actors in these associations. If the association receives a subpoena for records from law enforcement, they must provide a copy of all of those records within 5 business days. So it's a slightly different time frame there. But again, we're talking about a subpoena from law enforcement. So that's rare, but it could happen. And the association has to assist the law enforcement agency with its investigation. Again, keep in mind what we said, a lot of these are coming from.
And I'm just going to mention one thing before the next slide. The reason I'm answering some questions and not others, notice I don't have the ESQ after my name. Okay. So I'm just taking the questions that do not require an attorney's answer, even if I know the answer. I just don't want people thinking I'm ignoring them. So back to you, Emily.
All right. So now there are some crimes that are associated with official records. Because again, we made a lot of activity criminal now, because we want to make sure that our board members are doing what they're supposed to be doing and everybody's money is protected and all of that good stuff. So any director or manager who knowingly, willfully, and repeatedly, which is defined as 2 or more violations in a 12-month period, fails to provide access to the official records with the intent of causing harm to the association or one or more of its members commits a second-degree misdemeanor. So again, I don't love that one, because now a lot of times responding to official records requests, things get lost, things get misunderstood, miscommunicated. And I don't love the idea that there's a crime now associated with failing to provide access. It is repeatedly, it has to be 2 or more violations. It still is knowingly, willfully. But again, if you get a request to inspect the records, make sure you are appropriately responding to it. If it comes to you as the board, talk to your management team. If your management team gets a records inspection request, hopefully they've let you know, but hopefully they know how to deal with it too. And you guys are all on the same page. We don't want to sort of accidentally stumble into possibly committing or being accused of committing a crime. And it's no
Emily,
joke. Yes.
Emily, sorry for interrupting here. Now that you're mentioning management, it's very important that associations keep in mind that if you have any kind of questions about this, that you have to consult with your association's lawyer. Like
Yes.
the management team can support you, can show you the right way, but we don't do any law interpretation. So the best course of action, it's always going to your association's lawyer.
Right, right. If you get something and you're not sure if it's a records inspection request, exactly. And it might come through the board or might come through management. Talk to your attorneys and get a qualified expert response. So at least then you have an opinion you can rely on if something happens. Now, any person who knowingly, intentionally defaces or destroys accounting records, again, that sounds like something that should not be something we're all worried about, but it has happened. That is also a crime. I'm okay with that one. If you're destroying accounting records with the intent of, causing harm, I'm okay with that being a crime because that should not be happening. If you refuse to produce records, again, because you're trying to avoid being convicted of a crime or a crime being discovered, that is also that's now a 3rd degree felony. So again, we're not messing around here, guys. They want to make sure that we don't run into these situations again, where boards are able to these bad actors, I shouldn't say even whole boards, but these bad actors are able to hide what they're doing and steal your money. All right, official records rules. So like I said before, as a board, you could adopt a lot of rules in terms of behavior and, at meetings. Here, you can also adopt rules regarding official records and how owners can request them, how often, the time, the location, all of that. You can adopt rules. I suggest doing those with the assistance of your attorneys to make sure they are rules that would be enforceable if there were some challenge. You cannot require that an owner show a proper purpose or that they give you any reason for wanting to inspect the records. They just have the right to do it. They don't have to tell you why. They don't have to, it could be for no reason. That's fine. You can't limit an owner's right to inspect to less than 8 hours on a business day per month. We do it where it's sort of 2 sessions of 4 hours so that you don't have to block off a whole day, but at least 8 hours, you have to give them access. If they want to comb through, every single document and every single official record you have to let them do it. Copying records and fees. This is important too. We have owners that'll show up with, sometimes a portable scanner. I've also been at records inspections where someone just brings their phone and they take pictures of records, or even an iPad and they take pictures of records. If they're making copies themselves because they're taking those photos or they're scanning or whatever, and they brought their own scanner, you don't get to charge for that. That is free of charge. They get to take pictures. Too bad. If there's a photocopy machine available and they actually want copies, then you can charge. You can charge up to 25 cents per page if they're, again, using your Clubhouse copier or whatever it is. If you don't have a copier available or they want more than 25 pages, you can use an outside service. You could send it out to be copied and they have to pay for those copies, whatever the vendor charged you. So we're not making a profit here. We're just paying whatever it costs. Personnel costs. And I understand, and I hear you guys on this. Trust me, I've heard it all the time. But now our manager has to sit in the office all day and it's a waste of time and he can't do his other work and he can't, this is so frustrating, all of that. I know, I hear it, I understand. Again, don't shoot the messenger here. I didn't write these laws. The association can charge personnel costs if the time spent exceeds a half an hour. And if the personnel costs don't exceed more than $20 per hour. So again, I know it's not what you want to hear. That's not great, but that's what it is. Personnel costs cannot be charged if the record requests result in fewer than 25 pages being copied. That's the other part of it. Again, I'm sorry, I didn't make it up, not me. So that's just dealing with these official record requests. They are time consuming. They are a little bit of a burden on your management team for sure, but it is part of the business. It is a cost of doing business. And you guys have to, unfortunately, you have to deal with it. If you can get all these records on your website, that's going to help you though. Keep that in mind. Oh, perfect. Now we transition right into the website. So we already said, and hopefully you guys already know, 100 or more parcels by January 1st, you were supposed to have a website set up or a mobile app or whatever we're calling it, some online platform where your documents can be posted and can be uploaded. Now it has to be accessible through the internet. Now the owners have to get a username and password. You can send them out, a blast that they can sign up or that they need to contact you or whatever it is, or you could just assign them a username and password or a username, because there have to be documents that are protected and not open for everybody. You don't want everybody under the sun to have access to all of your records, obviously. You only want your owners to have access to certain records. So they need a username. All of these documents, I won't go through the whole list. This is everything that's supposed to be on your website. Obviously, it syncs up to a lot of your official records, but it's not quite everything. It's interesting that they put a list of your current contracts, but they don't actually say all of your contracts need to be on your website. Then where they talk about that, they talk about contracts between the association and any director or contracts regarding a conflict of interest. Again, strange sort of the way they worded this. And then notices, we already talked about notices. Notices should obviously be on your website. That one's very clear. Now, the association has to be careful. Any of the information that is not supposed to be open for owners should not be posted on the association's website. Same logic here. If they wouldn't be able to access it, if they came in for an inspection, you shouldn't be able to access it online either. So those things we talked about, personal information, attorney-client privilege, all of that should not be open for inspection. If there are things that need to be on there that have personal information, you need to make sure they're redacted. All right. Amending your governing documents. All right, let's get into this. And we have a class just on this alone. We could talk about amending your governing documents for hours, but we're gonna just keep this. Again, we're in board cert kind of HOA 101 land. We're giving you teasers of the basics here, and then again, if you guys want to get into details, you can always sign up for our other classes.
This is like we like to refer to this as the Costco version, a little bit of everything, but not a lot of one thing.
Right. All right. So generally to amend your documents, it's going to be a 2/3 vote of your owners, but look at your governing documents because they may require something different. If your governing documents say, it's only a majority of your owners, great, you can follow that. If you're still at 2/3, I'm going to suggest to you my unsolicited 2 cents suggestion here that you can take to the bank. You may want to consider amending your voting threshold first. Amend that voting threshold down to a majority so that you can, in the future, it will be much easier to amend and get those amendments approved. If it's 2/3, that's a little bit of a bigger hurdle to overcome. You want to convince your owners, obviously, that it's in their benefit, it's to their benefit to let the association be able to amend the documents much easier. So if you can get it down to a majority, that makes life a little bit easier for everyone. The format of how you amend documents is very specific. The statute provides if you're going to add language, you have to underline it. If you're going to take out language, you have to strike it out. That's how the owners can read it and know what's new, what's old, what you're taking out. If you're going to totally change a section, you have to indicate that this is a substantial rewording. And, there you go. Lender consent is an interesting consideration as well. The documents basically say, if your documents say something along the lines of this provision cannot be modified without approval of all mortgagees, or sometimes it'll say, you can't change the assessment recovery after a foreclosure because that affects a lender's interest without their approval. If there's anything in there requiring lender consent, mortgagee consent, however we're wording it, The statute now says that there is a process to get that, and that makes your life a little bit easier. Instead of trying to hunt down, someone at Bank of America who will sign off on this amendment, which would be insane. Instead, we can get the information for the mortgage. We can send out a notice, and basically it's like a negative notice written consent thing. If they don't respond and they don't object within a certain time frame, it's considered that they've approved and you can move forward. So that was a helpful change to the statute. Now, we get a question a lot where, okay, we amended this, we voted last night, so it's effective, right? No, it's not effective when the vote is completed. It's effective when it's recorded in the public records. So when you have that membership vote and your members approve an amendment, all well and good, but now last step, you need to get it you need to get a certificate and you need to get it recorded in the public records. Now that's a little bit easier. A lot of them will do it very quickly because we can actually e-record a lot of things. So make sure you talk to your attorneys and you can get your amendments recorded pretty quickly. Within 30 days of recording an amendment, the association has to give a copy of the amendment to its owners. Now, if the proposed amendment was given to everybody prior to the vote and it did not change, that's fine. You can just let your owners know that a copy would be available to them at no charge. And you can also let them know it's been recorded. Here's the instrument number, book and page, or whatever it is. All right, so now this is kind of our potpourri section, so to speak. That's the topic they used to use in Jeopardy, right? For sort of miscellaneous.
I think so.
So a few gems you should all know about. We're going to talk about governmental filings, meeting minutes, rules, material alterations, MRTA, debit cards, all this fun stuff. All right. This is kind of the quick section, one slide on each topic here. So 2 governmental filings you need to know about: the Division of Corporations, that's sunbiz.org or whatever it is. You need to file an annual report. You need to update that every year, and that's basically between January 1st or May 1st of each year, and you have to pay a filing fee. Okay, that makes sure your information is current with the state, who your officers are, what your mailing address is, whatever it is. And then annual income tax. So this is interesting. Assessments are not taxable income, but you may still have some sort of income. You may have whatever you may get. Here we have estoppel fees as income. You may have a laundry lease or something in your clubhouse, maybe. There could be something where you're getting income, maybe a cable, hot wire agreement, and the association's getting money from that, whatever it may be. So talk to your accountant. That's really not for us to weigh in on, but talk to your accountant because you may have to file a tax return. Meeting minutes. All meetings are supposed to have minutes taken. Now, what's in them is always up for sort of conversation, let's say. Your minutes don't have to be an actual full transcript verbatim of every, Then John said he doesn't like this proposal because that landscaper is not the best. He would like to hire landscape 1, 2, 3. That is not what needs to be in your minutes. Your minutes really should just have who was there, what motions were made, what action was taken, who voted, how they voted, that sort of thing. You don't need a whole, again, transcript of everything that happened at the meeting. That's not the purpose. Material alterations. This is typically a term that's used more in the world of condominiums than it is in HOAs. The condominium case that defines it is, even in the world of condominiums, not great because the definition is a little bit crazy and not as black and white as we would like again. So basically it says a material alteration means to palpably or perceptively vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. That was a lot of words. It is very confusing to figure out whether or not something is a material alteration. A lot of times you're going to need your attorneys involved in that. Now, most of the time, again, in the world of HOAs, we're not worried about a material alteration because most of your governing documents don't require a membership vote for a material alteration. Probably the statute does not require a membership vote for a material alteration. It's only going to be whatever your governing documents say. Now, your governing documents might have some sort of provision in there of if the board wants to spend more than $100,000 on a capital improvement, it needs a vote of the members, or a majority of the membership must approve such decision. Something along those lines. It may say something like that. That's what you'd be looking for. Really, a material alteration in the world of HOAs is probably something like, if you want to rip down the basketball court to put up a new pickleball court, or, rip down the clubhouse and put in a new club, whatever. Now, again, you have to look at your governing documents. That's really a document specific issue. Do we need a membership vote? Can the board do it on their own? That's all something that's going to depend on what's in your governing documents. All right, rules and regulations. Your governing documents should also authorize you to adopt rules. Typically, they do. Now, again, is it about use of common areas or the rec facilities, or does it specifically address you can adopt rules about lots? Because boards typically adopt rules. And now, does that include lot use, or are we only adopting rules about, common area use? Those are different things there. That has to be in your governing documents if you want to adopt rules about lot use. Now, also be aware that typically, while rules are adopted by the board, your governing documents are going to control here. If they say something like, and the board will submit such rules to the membership before, and get membership approval before the rules are effective, there could be language in there that says something like that. Look at your governing documents and make sure you're following them if you're thinking about adopting new rules. If we're adopting rules that do affect parcel use, like we said earlier, it's a 14-day notice for your board meeting, because that's one of the exceptions. Anything else would just be a 48-hour notice. And then obviously you would publish the rules once they're adopted to your owners so that they're effective. Marketable Record Title Act. I don't want to scare any of you, but I also am sort of going to scare some of you, maybe. If your governing documents are older than 30 years, you might have a problem. Now, I say that because the Marketable Record Title Act, which is Chapter 712 of Florida statute, says that 30 years is basically the lifespan of a covenant, and your declaration is a declaration of covenants. So after 30 years, your covenants expire. Now, there's a lot of complications to this. There's a lot of nuance, but that's what you need to think about. Now, you could preserve them if you've done certain steps, and that's just done at a board meeting. It's nice and easy. The board gets to decide. It's a written notice. It's filed. It's recorded. Board meeting, great. You're within your 30 years. Easy peasy. You've recorded them. You've now, prolonged your declaration's life for another 30 years. If you haven't, and the 30 years has come and gone, then potentially now you have to revitalize your declaration in order to be able to enforce any of your covenants. You may say, well, no one noticed, so it's not a big deal. We can just keep going on and we don't have to do anything and no one's ever going to notice. Well, what if one of those owners stops paying and says to you, you can't enforce because you're enforcing a declaration, but your declaration has expired. So you can't come after me. Too bad, I'm not paying my assessments anymore. Or somebody paints their house, purple, and that's not an approved color. Well, you can't enforce the ARC guidelines against me because the declaration is expired, and too bad. So these are the things we worry about, and we want to make sure you can enforce your covenants and your declaration. So make sure if your declaration is within 30 years that you've preserved, or you are preserving before that 30 years comes and goes, or if we're after 30 years, double check that you preserved within that time. Otherwise, you might want to think about talking to an attorney to revitalize. Make sure your declaration is enforceable for you. Emergency powers. This was changed to the statute, obviously, sort of after COVID to address that, just giving the association more emergency powers. We don't need to get into those details too much. Debit cards. This was an interesting change. Bottom line, what the takeaway here is going to be, what I'm going to tell you, don't use a debit card. Period. Don't use a debit card that's in the name of the association. Now, it says you cannot use a debit card that's in the name of the association. But then it goes on to say, if you use a debit card issued in the name of the association for an expense that is not a lawful obligation of the association, you've committed theft, and then a lawful obligation of the association is a defined term, and it means that obligation had to be pre-approved by the board, which is reflected in meeting minutes or in the budget. So if you use a debit card for an expense, even if it's a legitimate association expense, unless that was something that was pre-approved, or in the budget, you're going to run into an issue because now you've accidentally violated this statute. And again, it's considered theft. So bottom line, don't use a debit card. Do not use a debit card. All right, litigation authority. Now, associations, HOAs are a little different. The statute specifically provides that if the board is considering commencing litigation where the amount in controversy exceeds $100,000, and that sounds like a lot, but it also in the world of litigation is not a lot. If we're talking about maybe suing a developer or suing about your clubhouse or whatever it is, $100,000, you can get that, you can hit that number pretty quickly. If the amount in controversy is going to exceed $100,000, the association is supposed to get a majority of the voting interests who are present at a meeting, so a majority of quorum, to approve that action before the board just proceeds. Again, this is making sure your owners, our members, know what's going on, know where the association money is being spent. For that type of lawsuit, they want to make sure your owners are on board before the board just makes that decision. All right, architectural control, we talked a little bit about this. This was another focus in recent legislation. We want to make sure that architectural standards and guidelines that owners understand basically what the guidelines are, when they apply, what's going to be approved, what's not approvable, and why. So now it very specifically says that the association has to reasonably and equitably apply and enforce the architectural standards and publish guidelines and standards authorized by the declaration. So, just having a kind of loosey-goosey policy of the ARC will review your application, and if they like it, they'll say yes. If they don't, they'll say no. That's not going to fly. You can't just say, you can't have sort of this, that much discretion out there. We need to have guidelines. We need to have specifications. We'll allow fences, but only fences that do not exceed 5 feet, only white PVC fencing. You can't just say, oh, we allow some fences. Sometimes, depends on what the ARC feels like that day. Okay, does that mean shadow box? Does that mean wood? Does that mean only PVC? What, there's so many options here and so many possibilities. Can I have a chain link fence? What if the chain link fence is only 4 feet? Is that okay then? You need to have all of these guidelines and criteria really spelled out. Yes, we approve fences, but again, only not to exceed 5 feet and only white PVC fencing, or only the 4-foot shadow box wood fencing, no chain link fencing. Be specific so your owners know what's going to get a yes and what's going to get a no. If the association denies the owner's request or the application, they must provide written notice stating with specificity the rule or covenant on which they relied when they denied that request and the specific aspect that doesn't conform to that rule or that covenant. So if somebody submits a request for a fence, like I just said, and you just say no because we don't like that kind of fence, that's not going to work. You'd have to be able to say, because Rule 23 provides we only allow white PVC fences that are 5 feet tall, and you've submitted a request for a wood, brown, whatever, shadow box, 6-foot tall fence. Now, this is an interesting one. Not really sure how this came about, but here we are. The association cannot enforce or adopt a covenant, rule, or guideline that limits requirements on the interior of a structure that's not visible from the parcel's frontage or an adjacent parcel. Or that requires the reviewer approval of plans and specs for essential AC, refrigeration, heating, ventilation system. Again, if not visible from the frontage or an adjacent parcel. So basically anything that's going on inside the structure, the association, if it's not visible from the front, association is hands off at this point. This was an interesting one that came into play 2 years ago now, and we were kind of hoping it would go away, to be honest, and instead we've just extended it and added to it. So items on a parcel, this is a fun topic. So statute now says that regardless of any covenants, restrictions, unless prohibited by law, so there could be still be a code issue or whatever it is, an association may not restrict owners from installing, displaying, or storing any items on the parcel which are not visible from the parcel's frontage, an adjacent parcel, an adjacent common area. So if it backs up to a lake or golf course or something like that, or a community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and RVs. Now, I'll give you a fun fact. My understanding is this all came about because basically some lawmaker somewhere at some point in time wanted to be able to keep his boat in his backyard. And he was in an HOA that had a rule that you can't keep boats in your backyard. And here we are. Now there's a law that says we can't enforce a covenant that prohibits these things if the item is not visible from the frontage or an adjacent parcel or an adjacent common area. So if that person now wants to have a boat in their backyard and you can't see it from the front or from the sides or from the back or from a common area because they have a fence or they have hedges or whatever it is, now we can't enforce and we have to let them have the boat in the backyard. Again, in the world of, South Florida, when these properties are pretty small, we don't run into that as much, but I know in Central Florida and North Florida and the West Coast, people want to have boats and RVs in their yards. And maybe you can do it in a way where you can't see them from the front or the neighboring parcel. Here you can probably pretty much see them. Now, keep in mind, this is one of those changes, and I said we would come back around to it, where you want to talk to your attorneys about Kaufman language. Because potentially, if you don't have Kaufman language, this could be something that you could still enforce if your governing documents have this restriction, because you might not have to follow the statute on this. So something to think about, talk to your attorneys. This may be something where you can argue, you have a substantive right to prohibit RVs from being, put in backyards. And our documents say that, and they said that before, and we don't have to follow the statute's change on this one. Talk to your attorneys. Hurricane protections, bottom line, we won't get into this too much, but basically the association has to have hurricane protection specs. That's something that needs to be part of your ARC. You need to adopt these things. That can be many different categories: roof systems, shutters, garage doors, fuel tanks, all of that. That's all part of hurricane protection. Make sure you have rules in place about that. Okay, this is another one that gets us back into that Kaufman discussion, which again, I'm going to tell you, talk to your attorneys if this is an item that, gets under your skin, because we've had many boards that were very mad about this statute. But again, it may or may not apply to you, depending on the language in your governing documents. Vehicle restrictions. Okay, new law last year. Now the governing documents cannot prohibit an owner, tenant, whoever, from parking their personal vehicle, which includes a possible pickup truck, in the owner's driveway or anywhere else they're allowed to be in the association. Now, owner, tenant, invitee, whatever it is, can't be prohibited from parking their work vehicle anywhere essentially in the driveway. Now, again, I get questions about this. Well, we have a truck restriction. You can't have a pickup truck in our community, or you can't have a commercial vehicle. You can't have a work truck in our community. So now you're telling us we can't prohibit that? Well, again, we're back to that Kaufman discussion. Maybe your community can still enforce the restrictions it already had in place. Maybe it can't, depending again on the language and that whole argument. But talk to your attorney, because that's one that I know has gotten under a lot of people's skins. They still don't want to be able to have, or they still don't want to be able or be required to let owners park their trucks or park their commercial vehicles in the community. And I understand if that was the restriction you had, I understand why it would bother you that now the legislature said, just kidding, you can't enforce that restriction anymore. Contractor restrictions. This was an interesting one. Not sure again why this got put in here, but here we are. New law. Basically, your governing documents can't prohibit an owner from allowing entry to a contractor just because that contractor is not on a preferred list. And also not because, and simply because they don't have a professional or occupational license. You have to allow that contractor or worker into your community. You can't keep them out from, the security gate. Budgets and reserves. Let's get into this. We're an hour out, so let's try and speed through some of this a little bit. Your budget, for the most part, and we're not quite in budget season, but your budget for the most part is probably going to be prepared from with your experts. So your management team, your accounting team, they're all going to help you out with this. Your budget is supposed to be a reflection of your, you know, your last year's budget, and then adjusted and, you know, revised for this year based on what you think your estimated costs are going to be. We think our landscaping's going up, so we got to, you know, increase that line item. We think our legal budget, we can probably reduce that a little bit because we just settled that lawsuit and we don't have to worry about that as much. All of those things can be adjusted, you know, accordingly. It's really meant to be an estimate. It's not a, you know, hard and fast thing. It does have two main components: operating expenses, that's all of your expert fees, and that's, you know, your regular sort of paying your contractors and operating. And then reserves, if you have reserves, and we'll get into that. So operating expenses, like I said, that's your regular doing business, your management fees, your admin fees, paying your vendors, all of that. Reserves are an interesting topic. So reserves, and we hear this now, again, it's been more of a topic in the last couple of years. Hey, we don't have reserves. We're in trouble. We don't have reserves. If you are in an HOA world, it is very different than condos. And you may hear this is really where it's been coming up, is in the world of condominiums, and the way the legislature is now basically forced condominiums, to have reserves no matter what. Now, there was still a rule, well, the statute still required reserves, but owners were allowed to waive them previously. HOAs were totally different. HOAs, the requirements for reserves, what you've heard in the news, what you hear about condos, what you hear about, you know, structural integrity, reserve studies, and milestone, and blah, 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 blah. None of that applies to you guys. So you're in a different world when we're talking about reserves and we're talking about these items. So wipe all of that out of your brain and just listen to this. So you may have reserve accounts. You're not required to have reserve accounts unless your governing documents require you to, or the members have voted to create reserve accounts. And we'll get into that in a second. But basically, reserves generally are for these capital expenditure, big items, or deferred maintenance. You know, if you're going to have to redo your roads, if you're going to have to, you know, replace the clubhouse roof one day, those types of things. So the only times you need to have reserves, you're required to have them, the only time is if they're statutory reserves, which are created only two ways. They can be created by an affirmative approval of a majority of your total voting interest. So your members would have to vote. There would be a record because your members would have voted to create a reserve account or reserve fund. That is way one. Other than that, it would have to have been created by your developer, and there would be language in your governing documents that say you need to be funding reserves. If that is not the case, then you do not have to have reserves. If the board wanted to have a discretionary fund, a slush fund, if the board wanted to start, you know, keeping funds going because we know we're going to do that big project in a couple of years, that's fine, but it's not the traditional reserve account that you hear everyone talk about. Calculating reserves, it's typically pretty easy. You just sort of look at the remaining useful life of that asset and the total useful life, then the remaining life, then back it out math-wise and see how much you should be reserving each year. $100,000 for a new clubhouse roof. We have 10 years left, so it's going to be $10,000 a year we should be reserving to get us to that point.
Emily, it's very important to note here, sorry to interrupt.
Yeah.
That your management company should be able to help you deal with this because they do take care of your financials month to month. So they have the whole scope of work that you need, everything that you need for continuing to up the bar of the service that you have in your community. So having this open conversation with your management company, it's super important so you can get to a point where you're comfortable with your next year's budget.
Yes. Yes, thank you. And that's what I said, guys. Really, the budget is where you're really going to rely on your experts here. You really talk to your management team and make sure you're all on the same page, because you do want to know what you're looking at. You want to know what you're in for the future, and you want to be planning for these things. So we're not surprised by big special assessments and all of that. So make sure you are doing that. We want you to know what's going on with your finances. That's a big part of, you know, being on the board.
Exactly. And you need to have those month to month reports. So you actually know where your community is at and you can make those well-informed decisions.
Yeah.
Thank you. Jumping up.
Yeah, no, thank you. And again, you can talk to your management team about these items. If you want to use reserve funds for another purpose, that requires a membership vote. So if the board or if your membership team, or let me back it up. If your membership had established a reserve account maybe for paving the roads, and that was voted on, you decided we're going to have a road reserve. Great. And you've been funding that road reserve. And the only thing those funds were supposed to be used for were the roads. But now you decide, well, wait a minute, we want to repaint the clubhouse and some repairs to the roof. And can we just dip into that money we had? We have that roof money sitting, or road money sitting aside. Well, you could use those reserve funds if you get a membership vote to use them for something else. You could also have pooled reserves. You could have that reserve account set up for basically almost anything. Everything listed that you could possibly need a reserve, fund for, and then you have the flexibility to use those funds for any of those items listed in the reserve. Now, again, you only have to have those reserves if they're statutory, if the membership created them or they're in your declaration. Other than that, if we're just talking about, because again, the word reserve is used sort of very loosely here. If it's just a contingency fund that that your board created, it's not a traditional reserve account. All right. Notice of your budget meeting. It's only really a 48-hour notice unless your documents say something otherwise. You have to send a copy of the budget to your owners, and you have to post a copy of that on your website. All right, assessments and foreclosures. This is a big topic. Obviously, we do have the most important power you guys have on a board, or the association has, period, is to assess and then foreclose if someone doesn't pay assessments. And we hear it where people will say, well, wait a minute, we're not going to take someone's house away. They have a mortgage or it's homesteaded or whatever other comment they'll make. Let me be clear with you. You absolutely can record a claim of lien against a lot, against a parcel, and you can foreclose that claim of lien. You can do it if there's a mortgage. You can do it if it's homesteaded. So you might not foreclose out that mortgage. If that mortgage is superior to you, that mortgage may stay on the property, but you can still foreclose your claim of lien. You can still potentially take someone's home away. That is very, very huge. I mean, that's very important. So when people don't pay their assessments, be aggressive with your collections and really move these cases on, because you have that power, you have that authority as an association. Special assessments, we touched on this a little bit before. Special assessments are adopted by the board. Basically, it's supposed to be for an unforeseen cost, or maybe even it's a budget shortfall. But 14-day notice for that board meeting. That notice has to be clear, has to discuss the purpose, has to say you're adopting a special assessment, and has to give an estimate of what the special assessment is. If you don't have a finite number just yet because you're finalizing the bids, that's fine, but an estimated amount of that special assessment. And then again, you're adopting the special, and it's collectible in the same way a regular assessment is. Requirement to provide an accounting. This was a new change this year. A parcel owner can now make a written request for a detailed accounting of everything they owe, everything on their account. That can be sent, it's a written request, and the board has to respond within 15 business days. That's a new thing. So make sure if there's a question about someone's account, if it appears that they have made a written request for a detailed accounting, get with your management team and get with your attorney to see if this qualifies, and make sure you respond timely. If you don't, there's a penalty. So if you don't respond within the 15 business days, now it's a waiver of any outstanding fines that person may owe. So they don't wipe away all of their assessments, but fines. So potentially still the association could be losing some money if they don't comply. Collection of assessments. Like I said, this is the biggest, hammer that you guys have in your arsenal, so to speak. Assessments bear interest. You can collect late fees. You can collect interest. You can collect attorney's fees and costs. All of that is collectible when someone isn't paying their assessments. Application of payments. When someone makes a payment, it doesn't necessarily go to their January 1st delinquent assessment. It's going to go to everything before it gets to the assessment. So interest, late fees, costs and attorney's fees, then it's applied to the assessment. So that delinquent balance continues to sort of accrue and run until they've paid everything off. A notice of late assessment, or what you'll hear us sometimes refer to as a NOLA. So notice of late assessment or a NOLA. This was a new change. Well, I keep saying new. This was a couple years old now. And I'm sure this is something that Affinity handles for you guys. Basically, the statute changed to require an additional notice before the statutory notices. And this notice now you can't recover attorney's fees for this. So typically we tell our clients, don't have us do it because you're not going to get your attorney's fees back for it. Let your management team do it. And essentially, it's not that different than sending a late notice when someone hasn't paid. But I'm sure, Adriana, you can confirm Affinity does these for them.
Yes, part of our services, like when we talk about dealing with your financials, it also talks about helping you with your collections and, of course, keeping your accounting up to date. So you have all these NOLAs, now I learned a new term, all these NOLAs on time. So yes, your management company does help you with this type of work for your community. So you don't have to be an accountant, so you can be a board member. Your management company can help you do this for you.
And no, this has nothing to do with New Orleans, Louisiana. Okay, that's a different NOLA. Different NOLA.
It's a different NOLA.
Totally different.
So now the catch here is it's essentially a glorified late notice, I'll be honest. But the catch, like I said, is you cannot recover attorney's fees and you can't include attorney's fees at this juncture. Now, I'll give you some context for this because this one I find funny. This really was a legislator who apparently, I guess, I don't know if he lived where he lived, but he wasn't always home and he had various mailing addresses and he didn't get a late notice. And once he finally realized that his account had been turned over for collections and he was accruing late fees, interest, attorney's fees, all of that, he was very upset. And so now the NOLA, and he was the driving force behind this. So this late notice has to be sent to the lot, the parcel that the person owns, the lot or whatever it is, their address in the community, but also their mailing address. And you have to have an affidavit that confirms that you sent it to both addresses if they're different. If that person lives in the community and that's their only address, that's fine. But otherwise you have to send it to both. And again, the whole thinking was sort of an extra notice to make sure your owners really, 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 really know that they have an amount outstanding and it gives them one last chance to pay it before it goes into, goes to the attorney and those late fees and those other fees start to accrue. So it's a 30-day notice sent by management. If they pay, great, we're all done. If they don't, send it over to your attorney. Your attorney is going to send 2 other statutory notices before we can go to foreclosure. The first one says we're recording a claim of lien against the property and you have 45 days to pay the balance or we're going to do that. Second one basically is going to say, now we're going to record that claim. We're going to foreclose that claim of lien if you don't pay in another 45 days. Now, first mortgagee assessment liability, safe harbor. You'll probably hear the term safe harbor a lot. Basically, if the lender forecloses, if a first mortgage lender forecloses on a property, the association is not completely out of luck. You do get something typically, but you need to look also at your governing documents because potentially your governing documents are going to be handcuffing you more than the statute does. Safe harbor is 12 months of assessments or the 1% of the mortgage debt, and it's the lesser of. So sometimes that's not a lot that the association would get from that lender foreclosing. But you might be even worse off if you have bad language in your governing documents. And that brings us, again, that's a Kaufman language issue where if you have the bad language, that might control over what's in the statute. And this is one where the statute is actually beneficial and better than what you might have in your governing documents. So that's another point to think about. Third-party bidder liability, that's another issue. What if an investor buys it at the foreclosure sale? And so it's not a lender, it's a ABC Homes buys the property. What do they owe for the association? That's a good question, and it might depend on what's in your governing documents again. They may get the same benefit as the lender if we're talking about safe harbor, or perhaps they owe you everything, depending on the language. So it could be a big difference, and you want to look at your governing documents for that, and you want to talk to your attorneys and possibly get an amendment so that you maximize your recovery if a lender forecloses, if a third-party bidder ends up taking title. Financial reports, this is another one where, we're sort of in the world of money right now, but this is another one where you're going to rely on your experts here. Your management team is going to help you with this. This isn't something as a board you're really going to be doing, but you need to be informed. Financial reporting, each year the board has to prepare financial reports. Adriana, did you want to weigh in on this too?
Yes, I'm sorry. Just to chime in a little bit here with the financial reporting. So here at Affinity, just to let you know that when we start the contract with a new association, we may have a financial guarantee, but we commit to have your reports delivered on time at the same time every month, which is very important for decision making. So I think that this is something that you should have as an association, because that allows you to make smart decisions for your home, basically. So yes, just wanted to jump in. And also to kind of help here, Jeff, we're getting a lot of questions that are more into the lawyer side. So Jeff is supporting with some answers, but for these specifics that require a more like specific language, Emily will be answering those. It's just that I'm seeing also a lot of questions here.
Thank you. Yeah, because Adriana could see that I'm typing some and not others, and I don't want to feel like they're being ignored. So that's why.
Exactly. Please don't get mad with Jeff.
Yeah.
Take it all out on Jeff, not on me at all. It's great.
Not on me either.
Kidding. But guys, keep in mind, again, we're at a 3-hour course, and I'm going to try and answer questions at the end, but we may not have a lot of time. And it is sort of it's almost a sampler platter. We're hitting on a little bit of everything, what we think are really the key, most important things you need to be aware of. But when you have questions about your specific community or your specific documents, I'm not going to be able to answer them. I don't have your documents in front of me. A lot of questions are going to depend on the language in your governing documents. So again, don't shoot the messenger.
Which is similar to what I answered with Salvatore's question. I can't answer your question, Salvatore, but take a look at your documents. That was likely where you'll find your answer.
Yeah. Exactly. And that's why we'll have our information afterwards, so we can connect you to an expert, Emily, or here in the management side on Affinity, so we can help you answer these specifics.
Thank you both.
Thank you, guys.
Thank you.
All right. So financial reporting, the statute also requires that you do certain financial reports basically within the end of the year, whenever your fiscal year is over. It should be by the end of the year, or again, look at your governing documents, because that really sets up your time frame. Again, that's going to be something your experts are going to do for you. You're probably not doing it yourself, but there is a time frame and you need to make sure it's done. The level of financial reporting is important because, again, that depends on your total annual revenue, and that's what we're going with here. So the lower end, you're talking about just doing a cash receipt report, all the way up to a possible audit. So again, this is where your experts are involved, but it's important that you know that this is something that's supposed to be done every year. Interesting change from last year's session, from July 1st of 2024. Regardless of the association's total annual revenues, if it's an association with at least 1,000 parcels, they have to do the audited financial statements. So these levels of financial reporting and those thresholds you see there, those apply if you're, any other association. But if you are 1,000 parcels or more, you now have to do an audit, which again, sort of makes sense because they wanted to make sure that these bigger associations have more transparency and we know where the money's going. You can raise the reporting level. The owners could vote to go beyond whatever that statutory threshold is and do a more thorough evaluation if they want. They can petition the board. The board could also decide to do it. You can reduce the level. I guess I should move to the next slide. You could reduce the reporting level. That requires a membership vote. That's not something the board can do on its own. And also you can't do it for consecutive fiscal years, because again, we want to be very careful. We want to make sure everybody knows where money is going. Required financial or reserve disclosures in the financial reports. So we talked a little bit about this. If you have reserves, again, the only way you'd have them really true, honest reserves is if your membership had established them or they're required by your governing documents. Otherwise, if the board just calls them reserves, that doesn't make them true reserves. They may just be sort of a slush fund, a contingency fund, any of those other rainy day fund, any of those other terms you use under the sun. But if you do not have reserves, there's a lovely little disclosure you have here that you have to have on that financial report. And basically it warns you that you don't have reserves. So you might have to have a special assessment. And then if there's discretionary reserves, not the statutory ones we talked about, there's a different disclaimer similar that you could have a special assessment. Contracts and bids, let's get into that. Contracts, and this is where, again, your management team is going to help you with bids. They're going to help you, find some possible vendors. You're not just out there in the woods by yourself. Rely on your management team. Let them help you. They know what they're doing. They've done this for a long time. They've been around. So you're going to get bids. You're going to get contracts. We would also tell you, if when you get a contract, you get a proposal from a vendor, remember, you are running a business when you're on the board. I know sometimes it seems a little informal. It seems like, you live here, these are your neighbors, you're just it's a friendly, voluntary kind of thing, but you're running a business. Remember that. So when you get a proposal from a vendor, it is a legal document. You are talking about a contract. You should have your attorney look at it to make sure the association is being protected. Factor in a little extra to spend on this project because you really should have your attorney take a look. Now, again, obviously take into account, the cost of these things. Otherwise, you really want to keep in mind, certain things. Look at the services that are being provided, the frequency. If we're talking about landscaping, are they doing 2 cuts a month? Is it every 2 weeks or is it 2 cuts a month? What if it's one of those months where we're into 5 weeks? Are they coming the first and third week? Make sure you know the frequency of the services, when they're supposed to be doing what they're supposed to be doing. Get some details, have these things spelled out in the contract, in writing. If it's not, you're going to have a hard time enforcing it. Well, Bob told me they were going to come on Mondays. Okay, does the contract say they come on Mondays? No. If it doesn't say it, how are you going to enforce it?
Emily, it's also
Yes.
very important that you run these contracts with your community's lawyer, especially for termination notices, if there are any like late fees or any other thing that could affect your community. Like spending those extra bucks for having your lawyer review the contract can save you months of headaches, lawsuits, or anything of the sort. So it's super important, this part.
I'm glad you said it too, because it's true. We've had clients that come to us who have signed, $300,000 contracts that lock them in for years. And then they say, oh, these guys are terrible. Can you get us out? Well,
it's like,
we're gonna try, but it might not be so easy. You couldn't come to us before.
Or it might be more expensive than what you originally planned. So those extra really are worth it.
Oh, yes. Remember that, guys. You're running a business. You're running a business. So
that's
bids,
a perfect
like
definition.
I said, right. You're bidding, your management team is going to help you with that. If the aggregate cost of the contract is more than 10% of your total annual budget, including the reserves, you have to get competitive bids. Now, it does not say anywhere that you actually have to get 3, but obviously 3 is sort of the going number and the understanding. That way you can see you have a good, sampling of what the numbers are supposed to be. You can get more. You could get 5 bids. You could get 2, but again, that's probably not best practice. You're not required to accept the lowest bid. That's important. We talked about the business judgment rule earlier. You are not required to take the lowest bid. Maybe that vendor doesn't sit right with you for whatever reason. Maybe, when you, and I would also caution you, really look at the bids and make sure you're comparing apples to apples, because some of these bids will seem like they're lower, and then you look further and all of a sudden, wait a minute, it's because it doesn't include these other services that the other one does include. So that's step 1. Make sure you're comparing apples to apples. And then also, again, you're not required to accept the lowest bid. Maybe that vendor just, again, for whatever reason, you got a bad feeling. Maybe the vendor that's the most expensive is the same one that your neighboring community uses, and they rave about them. They love them. They came in and did a presentation for you, and you guys liked them too. You could go with them even though they were the highest bid. That's totally fine. Reasonable business judgment rule. You don't have to get competitive bids if we're talking about emergency circumstances. That's good to know. Another one, you don't need bids if that vendor is the only one, or is the only source of that item within the county serving the association. And I've seen that once before. There was some type of, but it was in the world of condominiums. It was one type of carpet, one specific carpet only made by one vendor in Broward County. And so they couldn't get a comparing bid because nobody else had the item. So interesting. Certain contracts are not subject to the whole bidding process. That's for basically your professionals, the attorney, the accountant, your community association manager. That's another one. You don't necessarily have to get bids. If you do it with the bidding process, your management contract can actually be made for up to 3 years. Estoppel certificates, and we have a lot of slides on this, and I'm going to skip through a lot of them, honestly. The gist here for you guys to take away, for the most part, is, again, estoppels are something your management team is going to handle for you. They may need you to assist, but for the most part, management's going to cover it. An estoppel is something that's requested from the association by an owner when they are buying or selling their lot, or they're maybe refinancing their lot, and they need to know certain information. They need to know, how much is due, if there are any, what the regular assessments are, if there are any outstanding or upcoming special assessments, if there are any outstanding violations. They need to know all of these things so they can get them cured as part of the closing or whatever it is. If that property gets transferred and a new owner comes in and you haven't completed your estoppel properly, and you didn't include all of those violations, or you didn't include amounts that are owed, you are estopped from then pursuing those items and pursuing that additional money, because you gave an estoppel that said this person only owes whatever, $500. You can't later on say to the new owner, just kidding, I forgot there's a special assessment. Your lot actually owes $5,000. That's not going to work. So you need to make sure your estoppel is correct and accurate, because whoever relies on it gets to rely on it. And if you didn't fill it out properly, you may have shot yourself in the foot. But again, for the most part, your management team is handling the estoppels, so don't worry about it. But it's important that you guys know that this is part of the business here. So like I said, it's requested from an owner, a mortgagee, generally as part of a transfer. It's going to have the information, the name of the owner, the lot, any other pertinent information. And the big thing is really the outstanding assessments and outstanding violations. Those are the big things you want to make sure are correct. Again, lots of information on here. You guys can read this. You'll have this at home. You can print it out. You can highlight it. You can do all that stuff. There are fees for when you're preparing an estoppel. You can actually charge for it, but it is limited by statute. So that's in there too. The estoppel typically is good for 30 days. Sometimes if that time period comes and goes and the property doesn't close, then they need a new estoppel, or they need an updated estoppel. That's fine. So the big thing here, this is the red writing here at the bottom. You waive the right to collect any monies owed in excess of the amount specified on the estoppel certificate from any person who in good faith relies upon the estoppel certificate, and from that person's successors and assigns. So that's what I was saying before. The big thing to be aware of with estoppels is, if you do not include everything that is owed, you do not include every outstanding violation, then you may be stuck and you may not be able to pursue those amounts, or you may not be able to pursue enforcement. So that's where estoppels can be important, because you want to make sure they are correct and that you haven't shot yourself in the foot. Covenant enforcement. This is important because we were just talking about violations. Let's get into it. So we teach a whole class just on covenant enforcement. I could talk about covenant enforcement for hours, because basically this is sort of the fun stuff of HOA world. This is everything that everyone complains about. My neighbor, painted his house purple, or my neighbor has a pickup truck in the driveway. We're not going to get too far into the weeds here, guys, but we're going to give you the basics.
If you're in the Boca area, Emily's doing this class live at the Farmer's Table, April 17th. You can register for that on our kayebenderlegal.com. So back to you.
I have 1 week to get my voice better here.
Yeah.
All right. So sorry about that, guys. So, all right. Covenants. We already talked about covenants in general when we were talking about the Marketable Record Title Act earlier. So remember, covenants are promises. That's the agreement. Those are the restrictions in your declaration. And the board has a fiduciary duty to enforce those things. If your declaration says, that we have architectural standards, or that we're a 55 and over community, or we have, whatever it is, guest restrictions, you as a board have to enforce those things. You are supposed to be doing that. If you have architectural guidelines that say the houses can only be, this realm of paint swatches, and someone paints their house purple, and that's not one of your options, Now the board has to do something about it. The board has to take action to enforce, to say, hey, owner, by the way, you were supposed to submit an application. You were supposed to only paint, one of these 4 different shades of white and gray, and you painted it purple. Purple's not on our approved list here. We need you to repaint your house. And if you are properly enforcing, and I say that and I mean uniformly and timely enforcing your restrictions, then great. Then you can proceed and you're going to be able to enforce all of your governing documents and you shouldn't have an issue. Now, timely, uniformly, these are the big key items here. If you're not properly enforcing and it's not timely and it's not uniformly, you're going to run into enforcement issues and challenges, and you may not be able to enforce these violations. Now, we say, because if you fail to enforce them, it may result in a waiver argument, a selective enforcement argument, and those are possible affirmative defenses that could come up. You could say, well, yeah, I painted my house purple, but 2 houses down, they have a purple house too. Why are you sending me a letter? You're selectively enforcing against me. Or I painted my house purple, but I did it 7 years ago. Why are you guys sending me a letter now? Yes, Adriana, you want to talk about affinities violations?
Well, I want to talk about the importance of your management company when it is time to take notice of these violations and to enforce or notice the homeowners, because we have software that actually supports this activity. So you can follow through, and there is no way that one neighbor will get a notice and the other one won't, because our managers are on top of it and they have the tools in order to follow up with these issues. And if you remember, we also did an amazing webinar on this topic that it's on our YouTube channel, which is very, very interesting.
Oh God.
It was a while ago, but still effective. Yes.
So affinities, I know they have a great program because they do track everything and all of that. And that is a key part of all of this. You need to make sure you're not, even if it is accidental, you can't send one neighbor a notice about a violation and not another neighbor, even though it's the same violation. You're going to run into an enforcement problem there, obviously. That should be common sense, but it happens all the time.
Yeah, but that's why you need support in that sense, so you can comply to these rules. So let me use the stage again.
Yes. So now you do have options for covenant enforcement. You send a notice, you let them know, hey, Article 10 says you can't have whatever it is. You weren't supposed to plant, a cactus in the middle of your yard. Whatever the violation is. You weren't supposed to paint your house purple. You weren't supposed to have a new tenant without getting approval first. And we see there's a new tenant there, whatever. All of these things. You send a notice, you give the person an opportunity to come into compliance. Oh, I'm so sorry. Here's the application for my, my ARC change. Or, oh, I'm so sorry. Here's the application for my new tenant. I didn't realize I didn't submit it. Some things are easy to fix. Great. Some things are not so easy to fix. Sometimes you have owners who are less cooperative. You might need your attorney to send a letter and nudge them a little bit. But also, keep in mind, you do have a whole bunch of tools in your arsenal here. You can fine people for violations. You could suspend their use rights. You could suspend their voting rights, potentially. There's self-help, potentially, if we're talking about a maintenance issue. Hey, we really need you to trim that hedge that's overgrown. And then also we can go to litigation to enforce compliance. These are all things you should know, because I go to a lot of communities where they tell us, we just really can't enforce. There's nothing we can do. We know the owners just don't listen to us, and too bad. That is not the attitude to have, but I hear it often, actually. So you can suspend use rights of the owners. Sometimes, again, depending on your community, that might not get you too far in terms of suspending use rights, but it is an option. Fining involves a fining committee. This is the biggest challenge. You were going to tell me that you don't have anybody who wants to serve on a fining committee. I know, I hear it all the time. That's the biggest hurdle. If you can get people to serve on a fining committee, then you can fine, and that's a little bit of it's a deterrent for people. Now, the board would first be the body to adopt the fine, levy the fine. It's $100 for the first violation, up to $1,000, unless there's something in your governing documents that lets you go higher than that. You have to provide the person with a 14-day notice for a hearing in front of a committee. Again, if you can find people for the fining committee. And then they have that hearing and the fining committee decides that they're going to approve the fine or they're not. Now, hearing has to be held within 90 days of issuance of that notice. The tricky part, like I said, is finding people to volunteer for the fining committee. The fining committee cannot be a whole bunch of people. It can't be anyone who's on the board, any officer, director, employee of the association, or the spouse, parent, child, brother, sister, or of an officer, director, or employee. So that is a lot of people that cannot serve on your fining committee. I understand, but there's got to be somebody you could get. You should really have 3 people. They should be owners. They can't fall into any of those other categories. So this is the problem. Like I said, I know I hear it all the time. Within 7 days of that hearing, the committee must mail or email notice to the violator, so to speak, of the results and how they can cure the violation if it's still curable. Again, hey, you still didn't submit that application, please submit the application. Now, if it's been cured before the hearing, the fine cannot be imposed. So if it was, hey, we need you to trim those hedges, okay, we're having a hearing because we're imposing a fine because you didn't trim those hedges. And then the morning of the hearing, the hedges are trimmed. Well, okay, now we're not imposing the fine. Problem solved. If the violation is not cured, then basically you have a 30-day deadline to pay that fine. And the other part of this is attorney's fees and costs cannot be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. So you're not going to get attorney's fees just because, the board had to have the attorney send a letter first or whatever it is, if it's before this time frame when the fine has to be paid. Now, if that fine is approved and the violation is not cured, now we can get reasonable attorney's fees and costs incurred. They can be awarded to the association. Like I said, a fine can't exceed $100 per violation unless there's something in the governing documents that lets you go higher. $1,000 is your aggregate, again, unless you can go higher. And a fine of $1,000 or more can actually become a lien on the property. So remember what I said before, the most important tool, the biggest hammer in your arsenal is that you can foreclose a claim of lien. If a fine can become subject to a claim of lien, you could foreclose because of a fine, but only if that authority is in your governing documents. And condominiums, by the way, do not have that same ability. And condominiums get very mad when I tell them that, but you guys do. And that could be something you want to put in your governing documents at some point if you don't already have it. Use right suspensions. You can also follow the same procedure for the fining committee. You could do the same thing to suspend use rights. We'll get into that a little bit too. All right. This is a weird one. Special considerations. They put this in the statute last year too. I don't entirely know why. So you cannot levy a fine for the following: leaving garbage receptacles at the curb or the end of the driveway within 24 hours before or after the designated garbage collection day or time, and leaving holiday decorations basically longer than indicated in the governing documents unless they're left up longer than 1 week after the association provides written notice of the violation. Okay, the garbage can thing, I have to be honest with you, I have many clients that has driven them crazy. I have one community, they're townhomes, but they are governed by 720, and they are, they're townhomes. So they're small, tight, lots and driveways, and they have garbage collection 2 times a week. If you can't find for somebody leaving their garbage out the day before or the day after, and you have garbage 2 times a week, that means 6 days out of the week, somebody could have their garbage cans at the end of the driveway. And again, in that community where those driveways are tight and the community is smaller, that's a lot of garbage cans that are not so cute and no one wants to look at them and they block the way and they're, it's an eyesore. But that seems to be the case. But again, we might have a Kaufman argument discussion about that same type of thing. Talk to your attorneys if that's something that you're interested in. I don't know why garbage cans drive people crazy, but they do. Use right suspensions, failing to pay monetary obligations greater than 90 days. So an association can suspend a unit owner's rights to use the common areas if they're more than 90 days delinquent in any monetary obligation. So that could even be a fine. And that has to be done at a board meeting. It would be a board decision. You could put it on your agenda for any board meeting that you're going to suspend any use rights of any owner who's over 90 days delinquent. And you could, every board meeting, you could potentially read off who's more than 90 days and then send them a notice. We properly suspended your use rights. So we've now, as a practical matter, it would really mean, so we've turned off your transponder, or we've turned off your clicker or your remote entry or whatever else. So you can't come through the resident gate, you have to use the guest gate, or you can't come into the pool or the clubhouse because we've turned off your key card. That's, as a practical matter, how you're going to suspend use rights. If you don't have that, if you don't have a gated community, or you don't have a key fob or key card that you can turn off, then this might not be, the most appropriate punishment in your community. If you do, it drives people crazy. I was, back in the day when I did some foreclosure work, there was a dad that called and he said, my wife and teenage daughter are going to kill me if I don't get our transponders turned back on. If they have to go through the guest gate one more time and sit in the guest lane and show the security guard their ID, my wife might leave me. What do I need to do to pay this off and get current, basically? So again, getting a transponder turned off because somebody is delinquent could have a great effect. You could get your money. So that's an important tool. Now, you can't prevent people from accessing the community. Like I said, if there's a guard gate situation, they have to be able to get in so they can, if they can't use the resident lane, they can use the guest lane. You can't not, let them access their home. Voting suspensions. This is something, if you're thinking about suspending voting rights, talk to your attorneys, because there was a recent case that has now sort of complicated this thanks to the Kaufman language argument and all of that, and whether voting is a substantive right, et cetera, et cetera. I don't want to get into it too much, but talk to your attorney, and you may be able to suspend voting rights as well. Mandatory pre-suit mediation. Basically, if we've done everything we could do, we've fined somebody, we've sent them notices about the violation, we've turned off their clicker, and the person still has the outstanding violation. The unapproved tenants are still there, or the house is still purple and they haven't submitted an application for the ARC change that they made. The hedges are still overgrown. Whatever it is, what's the next step? We're probably going to have to go to mediation and send them a demand for pre-suit mediation. If it's an assessment, if we're just talking about, they haven't paid assessments, that's not subject to this. You can go straight to court. You don't have to worry about it. But when we're talking about normal covenant violations, the regular, typical, again, they haven't done this, or they, need to do this, covenant enforcement is going to go through a mediation process. Now, the association could be on the receiving end of a pre-suit mediation demand. So if you get a letter that looks, again, like an owner is demanding mediation for some reason, obviously, I assume your management team is going to be looped in, but definitely talk to your attorneys. That's something that needs to go through legal, because you need to make sure you're timely responding to it. That's a letter that's going to be served. And it's going to say something like pre-suit mediation. The statute sort of outlines the form that the letter should follow. You have 20 days to respond. It lists a whole bunch of mediators. You pick one. Mediators, I mean, the whole process, I think most people are pretty familiar at this point with mediation. The mediator is typically an attorney or a retired judge or whatever it is, and they're supposed to be the objective third party. And if we can get, the association to sit down with the owner, with that objective third party, and say, okay, listen, Article 10 says you have to get approval for any ARC change, and they painted their house purple, and that's one of the ARC changes, and they never submitted an application. Okay, now what? And if the owner shows up and they participate in mediation, maybe they'll say, okay, I understand I'm supposed to submit an application. Can we just resolve this? I'll submit an application, or I agree to repaint my house, one of the approved colors, and then we're done here. Great. If it's something like, I agree to remove my truck or park my truck in the driveway or park my truck in a garage every single night, whatever, you can come up with various different settlements depending on what the actual issue is. But hopefully the third party mediator can apply a little pressure, maybe back and forth to both sides, can let each side know what the strengths and weaknesses are in their case, so that maybe we can facilitate some sort of resolution before having to actually go to litigation and file a lawsuit and end up in court. So you split the mediation fees. Those are split between the parties. Again, we try and work out a settlement there. If it's an impasse, if you can't work something out, then now you can proceed and you can file that lawsuit if you want to. Now, when you file a lawsuit, we're in a different sort of realm, and the association is actually entitled to get recovery of its attorney's fees if we're talking about a covenant enforcement issue, because the statute says you get an award of reasonable attorney's fees. Now, I can't promise you you're going to get every dime back, because judges often don't like to do that, but you are entitled to an award of reasonable attorney's fees. Self-help versus injunctive relief. So to back it up, when we were talking about, a violation, if we're talking about an association trying to compel an owner to maintain his lot properly, it's, overgrown, it needs to be weeded, it needs the hedge to be trimmed. That's something that's easy enough. Okay, it's a violation of Article 10 that says each lot needs to be properly maintained and in good order and blah, 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 blah. And that's fine. We can go to court. We can ask a judge to say, please instruct this owner to maintain his lot. Here are some pictures. It looks terrible. It needs weeding. It needs, new sod. It needs the hedges trimmed. That's one way to go about it. So we would go to court. We would ask for injunctive relief. We would ask a judge to say, owner, you need to do X, Y, Z. Or we would need the judge to say, owner, you need to stop doing X, Y, Z, depending on which kind of case it is. But typically that's injunctive relief. We're asking a judge to order the owner to do something. Self-help is the other option. If your governing documents say, you, the association, can actually do this, that might be a possibility too. And if it's something like landscaping, that's something the association might want to do. Oh, we can just cut his hedges for him, and then we'll charge it back to him, or whatever it is. And then we don't have to go through the whole process of a lawsuit. Jeff, did you want to say something?
No, I'm just getting ready because you're at the last.
This is it? Okay. All right. So I'm doing okay on time. So self-help is important because if it's something simple like that, hey, we can just have our landscapers go trim his hedges and whatever, throw some weed killer down, then easy enough. Now you'd want to see what your language actually authorizes. Can you actually assess if you spend that money, or can you get that cost back if you send your landscapers out? Again, do we have to go through the whole process of filing a lawsuit? If we can avoid it, great. But if we're talking about a bigger violation, perhaps the issue is we need him to, repaint his house, or we need him to replace his roof because the roof got destroyed in the last hurricane and he still has a tarp up a year later. Those are much bigger asks, and the association isn't necessarily going to go to the, lengths of taking out a permit on someone else's home and getting a new roof put on and all of that. So there are different degrees of when the self-help is helpful and when not so helpful, but that's something to be aware of. The language in your governing documents is going to control, and also occasionally it might kind of hinder you a little bit, because if you have the requirement that the association is supposed to take these additional steps, you may have to do that before you can pursue any sort of claim in court. And that's important to be aware of, because if you just try and file the lawsuit, the judge may say, well, wait a minute, you were supposed to try and, again, repair this thing or do whatever, trim the hedges on your own, association, and you didn't do that. And because of that, you're not going to win this lawsuit. So that's an important consideration. It could be something that sort of cuts both ways. You might want to add it into your governing documents. You might want to remove it from your governing documents. The option to have self-help. So something else, that's another possibility to help you with sort of covenant enforcement. All right.
That's a mouthful.
Covered it all.
Yeah,
okay.
Yeah. That's crazy. It's
and with 20 minutes to spare, that was
I know. Now I have to look at some questions for people, but you guys can give them the spiel while I do that.
Yeah. While you're doing that, and it's funny too, with the covenant enforcement aspect, technology is a wonderful thing, but it also makes things difficult, because there's a case that I was recently made aware of locally here. This is not in Florida, but something about holiday lights, about not leaving them on all year round. Well, with these new smart lights, for example, you could put these smart lights outside and make them green and red for Christmas and not take them down. Then 4th of July, you can make these smart lights red, white, and blue. So it's just crazy. It's what the language says. Does the language say holiday, or does the language say Christmas? So it's insane. It's technology. It's insane.
That's why you need to ask your lawyer, because that's where interpretation comes in and everything becomes so difficult. So your lawyer is your best tool here to not get into trouble.
That's what Emily is for. It's
exactly.
when I was on the field and I'm managing and I get asked all these questions, I would sometimes make the mistake of opening my mouth when I should not have. So if you're a board member or a CAM, do not make that same mistake. You know?
Yes, remember, guys,
Good advice.
CAMs are not supposed to provide legal advice. So again, they may know a lot because they're licensed and they know what they're doing for the most part and they have lots of experience, but certain things you're gonna have to run by your lawyer. And if they tell you you have to run it by your lawyer, it's because they know they're not allowed to tell you. Sorry.
Yeah, it's one thing to say the law says this. It's another
Right.
thing to interpret that law. That's two different things. Two different things.
Right.
Totally
So
different.
before Emily and excuse me, I'm about to cough, and I promise I did not catch this digitally from Emily.
I was gonna say I haven't been anywhere near you, Jeff.
Oh, yeah.
Don't blame me.
Emily and Adriana are going to go through some of the questions. Yeah,
Some of them I'm not sure. Some of them just seem to be sort of statements. So thank you. Thank you, guys.
Yeah, there's one here. Can I address if that's okay with you? Because
Sure.
this appears a few times here. Chris is asking the famous question about going into further about what is allowed to be discussed on non-advertised board. Like if a board gets together and goes out to dinner, is that a meeting?
Yes. Yes. So we should, no, that's a good question and we should talk about it. Now, I will give you a disclaimer that attorneys disagree on this. So
I almost typed that, but I refrained. I almost typed that.
yes, because now again, you guys are in HOA land, 720. For the most part, you're not really subject to the division too much. The division really is more involved in condominium world. But I will tell you, the division has a very conservative approach. So condominium world, you end up sort of having a more conservative approach. Typically, though, our approach as attorneys is we are trying to be practical here and logical for everybody. If 3 out of your 5 board members are friends and you guys go to dinner, is that a board meeting? I don't think so. Now, the definition is a quorum of the board gathered to conduct association business. If 3 out of the 5 of you, again, go to brunch, is that a board meeting? I don't think so. If 3 out of the 5 of you meet, regularly to discuss association stuff, now we're getting into a bit of a gray zone here.
Emily, hey, I'm your client. Let's say I hire you, you're my attorney. And I'm like, well, Emily, how the hell am I supposed to get together with my board and come up with the stuff that's going to be discussed at the board meeting? This makes no sense.
Right. So now if you are really not making any real decisions, you're not taking action, you're not voting on anything,
Right.
but you want to sort of touch base, maybe workshop some ideas. Hey, we had this vendor that wanted to come out and give us some samples for our new, sign out front. You want to meet with that vendor. I don't have a problem with the quorum of the board doing that, and then bring your decision to a duly noticed board meeting and make your motion there. We want to make a motion to approve hiring, signs 1, 2, 3. And this is the presentation and we've all reviewed it and here we go. Oh, we like this. We don't like this. We like the, whatever it is. Do that part at the duly noticed board meeting. But you could, again, our take on this is you can have workshops, you can have sort of informational sessions where it is a quorum of the board. If you want to be uber conservative, then don't have a quorum of the board together. Maybe just 2 of you do, have these meetings with vendors or whatever it is. And then you report back to the board at the next board meeting. That's the very conservative way of handling it. If you're concerned that anyone's going to say you're having secret board meetings. But if you're just, again, I have a community where they're self-managed. And so it is 3 board members out of 5 in the office almost every day. One of them is there, sort of going through some records and doing whatever. He's the treasurer. One of them is the president. And he, is in the office to take payments and whatever, answer questions and do whatever they need to do. So it's 3 board members hanging out in a clubhouse in the office basically all day. Now, and they ask that question, we're conducting association business because that's what we're doing all day. We're in the clubhouse. We're answering questions. We're doing all this stuff. Again, I don't know how that works when you're self-managed. I think you have to look at it with a practical lens. Don't be making board decisions unless you're doing it at a duly noticed board meeting. Now, worst case scenario, if you have a crisis, we need to decide, we need to let the insurance agent bind us by tonight, and we don't have time to post a 48-hour notice. They need the answer tonight. Then fine. Then a majority of you can decide, yep, let's go forward with it. and then ratify that decision at your next duly noticed board meeting. So your owners know what's going on. That's the key. You just don't want it to look like you're keeping secrets, you're doing things in the dark. You want it to be transparent. You want your owners to know what's going on. You want them to, you know, again, not feel like you're doing things in the dark.
Yeah, Emily, and if you're meeting, like, for example, at brunch or something, there are no minutes. So if you
Right.
don't have no minutes, like, did the meeting actually happen? Like, I think that is another thing that could be questionable there, like meeting outside of those, official meetings.
Right. Right. Now, again, sometimes it comes up, you're hanging out by the pool, 3 out of
Yeah.
the 5 of you, you're just sort of chit-chatting. Oh, how are your kids doing? Oh, I see you guys went to, you went skiing for the holidays. How was that? Oh, how was your spring break? Fine. That's fine. 3 out of the 5 of you are chit-chatting, not a big deal. Now, something might slip in. Oh, hey, I see the landscape guy put those new flowers in by the clubhouse. They look great. Uh-oh, now are we talking about board stuff? It is a fine line, but again, emphasize, being practical and making your decisions at duly noticed board meetings so people won't think you're doing these things secretly. That's the big thing. Now, you're
Jeff,
muted.
you are muted.
Thank you. After you fill out your evaluations, you're not required to stay for the Q&A. So I know so a few of you are asking that. You don't need to stay on now that the slides are done. Submit your evaluation.
Please let us leave.
If you like, but you don't have to. This part's not required.
Someone also asked about the annual meeting if there's no quorum. So we did talk about that a little bit. Basically, if there's no quorum at your annual meeting, you are not having an election because that's the whole purpose of your annual meeting. So the old board just rolls over. So that's where I was saying we do have those associations that will tell me I haven't had an election in 20 years, or we never have an election. Our board, I don't even know how people get on the board. That's probably the case. You probably just haven't had quorum. And the annual meeting is sort of everyone walks in, up, no quorum, see you next year, guys, same board, bye. And it takes 5 minutes and there's no election because of that. So again, if you want to get on your board or you want to sort of force an election and change things up, look into that. You can probably get some proxies. Maybe you can knock on some doors and get things to change. Let's see. Someone said, what if we have a board member who hasn't attended a meeting in 6 months and there's no communication? What do we do? Well, and we get that question a lot. We have, sort of a board member we think is kind of dead weight, basically. And I got to be honest with you. Sometimes a board member who's dead weight is better than a board member that creates a lot of problems. So you can't just kick them off the board and say, well, they haven't come to meetings, so I'm going to say they're not on the board anymore. Maybe you could approach them and say, hey, it looks like you're not really interested in being on the board. Did you want to maybe resign? They could resign. Maybe they'll say, okay, fine, give my spot to somebody else. I'll resign. If you can handle it in a friendly manner, that's your best bet. Otherwise, just function without them. As long as you can get your quorum requirement, you could still vote on things. Just, again, maybe at the next election, we try and support some other candidates. Maybe you convince them to step down if they're really not being helpful. I know that's hard because people say, I'm the president and I end up doing everything because nobody else helps me. We hear that too. Let's see. If your community changes management companies, does the old management company have to give the association the old records, or does the company keep them? No, they are the association's records. They should be passed along. I'm sure Adriana hears this all the time. As soon as you guys take over, half of what you're doing is probably,
Exactly. This is part of the transition process. So yes, sometimes there is some information like for collections and all this that the other management company keeps, and it's a little bit more difficult, but we have processes in place to get this information. But as far as records or documents that belong to the association should have easy access so they can provide it to the new management company. But we go over this while we do the transition because it's not like, oh, I wake up one day and I have a different management company. This is a process that takes 45, 60 days, depending on the characteristics of your contract, of your association. But yes, we're here to help, but those association documents are of the association.
And guys, also the statute actually says they have to turn them over. I mean, they could be in trouble because again, they're licensed. So if you're having trouble getting records or they're just not, they're not responding or they're refusing to turn them over, talk to your attorneys because maybe you need to take a little more of an aggressive approach to get your records, but you are entitled to get your records. They're supposed to be turning them over to you or to the new company, whichever, is easier. Somebody asked about email addresses in a member directory. Email addresses are a hot topic. So if you have opted in to get email notices via email, now essentially your email address is open for inspection and other owners can see it. If you have not opted in for any electronic communication in that way, you don't do electronic voting, you don't do electronic notices, your property manager just happens to have your email address because maybe you emailed them one time with a question, then that is not the same thing. If you have done the consent, then you have understood your email is going to be open for inspection. Then that email address somebody could access and somebody could get. Otherwise, no, the email addresses should not be, sort of out there for everyone to see. Now, again, in a member directory, I would let owners specifically opt in if they want to put their email address in a directory, and maybe they do, because maybe it is easier to just sort of have a whole email blast or whatever. But a lot of people really don't want to get lots more emails, so you'd have to see. Let's see. All right. So somebody asked, and this is a good question too, the rules regarding official records and the 10 days and the $50 non-response, blah, 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 is that only if it's a certified letter, or could the request be via email? Now, technically the statute says that if you receive the request by certified email, then it creates that rebuttable presumption. But that's a rebuttable presumption. That doesn't mean that's the only way. So if you want to make sure that that you're only obligated to respond if it's certified mail, you might want to adopt some rules that clarify that, emails are not going to be acceptable. Somebody jotting down on a memo pad and handing you a scrap piece of paper is not going to be acceptable. Talk to your attorneys, adopt some rules to get that in place. What if an owner gets documents and posts them on social media? Oh, story of the times. That's not unusual. Again, official records are open for inspection, and whatever the owner does with those official records is really on the owner, not on the association. If somebody individually wanted to have a claim of some cause of action or a claim against that owner, they could pursue them. But ultimately, the association is not liable just because an owner posted, the delinquency report on Facebook. Now, again, that owner might have, to answer for some things or from some particular owners. We've had that where, somebody got the latest delinquency report from the official records, from the inspection. They made 1 million copies, posted them, out in the community, and because they hated their neighbor, and, said, Mr. Smith just bought a Jaguar, but he hasn't paid his dues in 9 months. That's not on the association. That information obviously came from the association, but that is between, that owner and Mr. Jones. So the association should not be involved there. Let's see. I'm not sure. Is it acceptable to do silent email voting as a board? We talked about that when the community is not involved. No, so you're not supposed to vote via email. That's what we were talking about. Let's see. We have an HOA company. The person who's our manager takes notes and records. As a new secretary, I'm also taking notes. I was told mine are only a secondary document in case needed. Is this true? Really, that's between you guys. If you have a manager who will take the minutes or take notes, great. You can delegate those officer duties to them. If you want to, make your life easier, you don't have to take notes. Cool. If you also want to take notes, also great. If you want to take notes and tell your manager they don't have to, also fine. But really talk to your management team, and it's whatever the board wants to do. If the board tells you we'd rather have 2 sets of notes, and then, if anything it gets missed, well, obviously that'll be less likely. But it's really up to the board and up to you guys and what you talk about with your manager. But yeah, typically your management team will do the minutes for the meeting, and we'll take notes for you, which is again nice.
Yeah, exactly. Your manager takes care of everything, just setting up the space, like all of those details. So you just have to come in and be part of the meeting, because here you are the owners. You're the ones responsible for all the decisions.
Yeah.
Mm-hmm.
Let's see. Right. Percentage of owners in favor of creating a reserve account would be a vote of meeting, a quorum. Yes. So if the owners wanted to create a reserve account, now again, not just a sort of slush fund, extra money, whatever, but create a reserve account that's going to be funded every single year, that would have to be something that's presented as a vote of the membership, and a majority of your owners would have to approve that. And there'd be a record of that, because again, it would be done at a meeting, there'd be minutes, there'd be, you know, all of that. Someone said, if you're given architectural approvals and then someone builds something else, what could the remedy be? Oh, good question, because we get that a lot too. Yes, if you only got approved to build whatever it is, you know, you were allowed to install a 5-foot wall and instead you installed a 7-foot wall. Well, now there's a violation there because you didn't have approval for that. So you'd pursue it. It would be the same thing as any other covenant enforcement action. You would pursue that. And again, you may end up in court together. That's not one of those self-help things really, but it would depend on, again, what they did. Let's see.
Do a couple more. It's 1 minute of.
All right.
And then again, folks, I will remain on for those of you having issues, and I'll go over the evaluation process much more slowly than I have so far.
Yeah. What can owners do to force boards to enforce covenants? Again, sometimes that's a more complicated issue because, again, your board members do have a fiduciary duty. They are supposed to be enforcing the covenants. But there may also be other reasons that certain things can't be enforced, either because the violation was there for too long, or again, a selective enforcement type issue. So there is a bit of a business judgment issue if the board can't enforce something that maybe the owners don't realize, you know, what the whole context is there. Let's see. Somebody said, I thought the law changed with the fine. No, fine can max out at $1,000. And again, depending on your governing documents, you could actually maybe even go higher than that. So $100 per violation up to $1,000.
I saw one question here, Emily, that says, our property manager is not doing a good job. Is it okay for 3 board members to meet with the, I guess, property manager to voice our complaints? And yes, like when you have a management company, you can reach out the customer care team. So we know we have the proper procedures in place. So if you have any complaints or if there are any issues within your community, there is more options for you to go over this. So you're not alone, and the company will support you. That's something very important to keep in mind.
And realistically, guys, it's not, you know, it's not super simple to just change management companies because there is some time involved in that transition. So if you have a manager and maybe it's the individual manager that's just maybe not a great fit for you, I don't know.
Exactly.
Maybe talk to the company, maybe they can assign somebody else, or maybe there is just something where, you know, it's certain things that aren't being done. And if you guys sit down and have a conversation, you will get better service once they understand, oh, we didn't realize that you wanted to get those reports, whatever, every 2 weeks. We'll make sure that's done. You know, obviously there's a lot of wiggle room there to talk to your manager or talk to the management company and try and get the service that you should be getting.
Exactly. So, I can only speak with the affinity case, but we work in a partnership. So partnership also means having these tough conversations, but getting to a point where we can reach an agreement. So yes, conversation will be step 1 to deal with this kind of issue.
And I'll be realistic too, guys. I know there's a lot of comments where, because we hear it, that the manager, you know, maybe is overwhelmed, or maybe you were realistically, maybe you're only, you know, contracting for part-time manager work, but you want full-time manager availability or full-time, you're really giving them tasks for a full-time manager. So sometimes there's a little bit of a disconnect there, and the management team will tell you, hey, you know, realistically, if you want us to be able to do all of these other things, then we can't have a part-time person here. We need to be full-time, or we need to, you know, increase these things.
Or have an on-site team.
Right, or have an on-site team. So, you know, obviously there's something out there that will resolve the issue. You just have to talk to your management team and figure out what it is.
Here's one that's kind of cute, because Emily, Alan, and we like to bring pop culture into some of these sometimes to break up the monotony. And one of the questions here, if someone is given architectural approvals and then builds something else, what could a remedy be? And I would say you call Miley Cyrus. You come in like a wrecking ball, right?
I was wondering which way you were going to go with that. That's not
one of my better ones, I guess, but you know, I try.
I thought maybe you were going to start singing Jason Mraz Remedy, that song. That's where my brain actually just went very quickly. So.
Yeah, I just thought of a bulldozer maybe, but just being a little bit more extreme. No, but just kidding. Yeah, everything lies out in conversation. Like if you don't have those tough conversations, you might end up with your architectural restoration a little bit different than you thought of.
Right. I mean, we have that now. Somebody, you know, asked to build a a pergola of this size, and then lo and behold, built a pergola that was this big, and it's a whole different world now. Neighbors were not happy.
Yeah.
Yeah.
Well, Emily, I know you have to run for appointments and stuff. So, parting words.
I do have to work a little bit today too.
Yeah. Got to rest that voice. And after the ladies give their goodbyes, I am hanging on to help you all with your evaluation. So don't worry. I see some of the questions here. If you haven't already done so, before the ladies say their goodbyes, open up the chat area. The Q&A and the chat area are two different modules. Okay, different things. So at the bottom of your Zoom interface, there's a little button that says chat. Press the chat button once, simply so it appears. If it says it's disabled, don't worry about it. I can still send stuff your way. So hit the chat button just so you see it. Ladies, parting words for each of you, please.
Adriana, thank you so much. This is fun.
No, thank you, Emily. I just wanted to thank you, Emily, and you, Jeff, for helping us co-host this wonderful event. It's actually amazing every time we have you, Emily. Conversations with you, we get pop culture, we get a little bit of everything, so we're just right on point what we like.
I came in like a wrecking ball, and
You'll never forget about us.
Definitely won't sing. And again, sorry guys for my voice. I know, like I said, something going on with sinuses this week. But thank you everybody.
It is allergy season.
3 hours. I know it's a long one, so thanks for hanging in there. But now you got your certification done. Yay!
Yay! So thank you all to the board members too who have participated. Jeff will of course let you know more. And if you also have questions on the management side, you can reach out to us at managedbyaffinity.com or info@managedbyaffinity.com, and we'll connect you with the right people. And remember, if after you do the evaluation, depending on your region, we have a particular team member that can attend all your questions or anything you need. And we also have that wonderful gift for those who sign up. So you have some other tips from the management perspective about what to do with very important items like financials or like tips that you can take care of, because this is a volunteer work. So we want to make this as easy as possible for you. So again, Emily, Jeff, this has been amazing, and it's always so great to meet you guys.
Thank you guys. Thank everybody. And Jeff will help you out. My email's there. If you have questions, shoot me an email. Thanks for sticking through it. I know, again, 3 hours, and sorry about my voice. But yeah, I'll see everybody next time.
See you, Emily. And in case you want to reach out to me, my email is al@managedbyaffinity.com. I'm also available to help you with any questions or anything you need from our side too.